Hey, how's it going, everyone? We're supposed to be having a Sarah Boone hearing right now. It was supposed to happen about an hour ago. However, the hearing was supposed to happen yesterday, but Florida had a hurricane. I think it landed yesterday, and so I hope you guys are doing safe out there. Hope everything's okay. But they decided to reschedule the hearing for today, and I don't know if they had like a live session or if it was only on Zoom. I know for sure some of the attorneys were going to dial in on Zoom, but Court TV didn't have their feed up. But usually, what happens is that Court TV will usually post it on their thing, and then sometimes it's delayed, which is okay. Because I know they used to do that before for some of the Sarah Boone hearings. Because I think previously the hearings were not always, they weren't always live. Hi, Madison. How are you doing today? How's it going? However, in the meantime, while we wait for perhaps Court TV to post that, there are some new motions on the Orange County Clerk of Court's website. So, some back and forths here, something about we did hear about this in the hearing where Sarah Boone wanted to have someone to do her hair. She wanted someone to do her makeup. Honestly, though, with the hair that she has right now, I feel like the hair is going to be very limited. I don't know what they're going to be able to do with her hair. It's already so short. I feel like just it's already clean looking. Looks fine to me. Makeup, I guess, refreshen up a little bit to make it seem like she's seen the sun, maybe. But there was that, and then yeah, let's just read the motions as they're popping up. It seems like they're doing all the motion stuff, and the court minutes are already up here. So we'll just wait for Court TV. They'll probably post a thing. Hi, Sam. How are you doing today? Yeah, happy Friday, everyone. Hello, hello. Hi, Sally. Is it live yet? Nope, I don't have it, but I keep refreshing my pages to see if it pops up. We'll cover it. But for the time being, we'll cover all the motions that are being posted right now, the court notes, and there was a hearing that happened yesterday. Kari Morrissey's back, okay? You guys, Alec Baldwin case was wild and it's been dying down. It's been sizzling a little bit. However, there's still Hannah Reid. Her attorney wants her to, either be free or maybe have a new trial. So I always enjoy hearing Kari Morrissey's arguments, even though Kari Morrissey, she's kind of a shame on, someone who is a special state prosecutor. But I always enjoy her. She's got the spice that I like. So we're definitely going to watch the motion for that one. But we'll wait. We'll wait until they post the live or they'll post the feed from the Sarah Boone trial. But let's look at the court minutes really quick. Let's see. Hi, Mandark. How are you doing today? Hello. What's going on? Mandark, I was reading your about me the other day on the Discord. Hello, hello. Hi, Kay. How's it going? Thank God it's Friday from Buffalo. Hi, Bridget. Hello, hello. Hi, Rena. Hi, Clint. Really? Appearance? Is that part of her act? I mean, she just wants to look good for the jury, But I honestly think her appearance right now is not bad. Every day or all these times that she's been showing up in court, I think her hair looks fine. I mean, it's short, She doesn't look haggard or anything. She looks okay. So I think just give her some few clothes and maybe she'll be all right. But they're fighting for her right to a hair, cosmetic, civilian clothes without restraints for trial. So I don't know. Do you have a right to someone like professionally to do your hair and your makeup? I thought maybe they will just run to CVS and maybe just throw her some some Maybelline or something. And then as for hair, it's like, here you go, here's a hair tie. Do what you want with that. But let's see what's going on with the court's website. It just keeps updating. I'm sure they'll update more stuff. All right, Ms. Boone. What do we got going on here for Ms. Boone on a Friday? Per the court comments, the defense must file a motion to suppress by the end of today. The court will rule on defense motion as it relates to hair and makeup in chambers. All right, we'll wait for that. Court minutes, comments. The state to depose Dr. Brennan in person no later than Thursday, October 3rd, 2024. That's going to be in less than a week. Dr. Brennan, is that the crime scene crash reconstructionist, death investigator, long name title? Is that Dr. Brennan? That sort of sounds familiar to me. The state's response, comments, motion to strike defendant's motion to suppress statements at Orange County Sheriff's Office, and motion to strike defendant's motion to suppress statements at Orange County Sheriff's Office. All right, so I'm sure they make these arguments in person. This is the defense's motion for right to hair, cosmetics, civilian clothing without restraints. I think the restraints thing, I think the judge had already allowed that. Sarah got that when she was doing the pro se stuff. State's response. State's response. I don't think we've read these yet. These are posted today. Because I saw these pop up earlier, but the files weren't uploaded yet. Just the title and then the description. Notice of filing. Witness list. Order granting defendant's motion to appear on Zoom. Okay, so that already covered. Motion to suppress. Did I read this one? Let's see. What is the motion to suppress? Motion to suppress. Oh, is this the one with the interrogation? Okay, we covered this one already 2 days ago. Yes. You guys haven't seen it yet. They want to have the 2-hour interrogation video suppressed. They're trying to say that Sarah Boone didn't have her Miranda rights read to her fully, correctly, and therefore get rid of the interrogation video. So good luck with that. Good luck with that. Let's see the state's response. Let's see. Notice the provision of discovery. So Assistant State Attorney, Mr. J, gave the defense dis number 9, Brady, Detective Colpsall. So Detective Colpsall is the one who read the Miranda rights. State's preliminary and objections to defendant's amended exhibit list. What is this? 1. On September 26th at 7:21 p.m., the state received an amended exhibit list from the defendant. Number 2, this is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for a potential extension. Number 3, the potential admissibility of battered spouse evidence has changed the feasibility of all court's deadlines in a scheduling order from August 5th, 2024. Number 4, items 1 through 3, which the defendant has not even have yet, will likely require hearsay relevance and 90, that's a 0.403 objections to be made. Is it supposed to be 9? Is it 90? Resulting in either the exclusion or voluminous redactions to be made. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be redeposed. Do you guys think there's going to be a continuance? I know Judge Krennic was like, no continuance, but I feel like there's a lot more that's coming into the, the court stuff. Number 5, items 4 to 7 are police reports. Police reports are inadmissible hearsay in Florida. It's unclear whether the defendant believes she can use these reports in her case in chief or for potential rebuttal. I remember in the Karen retrial, there were reports that the jury wanted. The jury was not given reports because the reports are not really considered like evidence. It's considered hearsay. And if I remember correctly, you can use someone's report to impeach them on the stand. So, for example, if you go up there in the stand and you say something inconsistent, maybe they can pull your police report and be like, oh, actually, you know what? In your police report, you wrote this, you wrote that. So that's what I remember about reports, because for me, I like looking at reports. And when I found out that, juries can't really have reports, I'm like, oh, wait, why not? I feel like I love reading reports, but I guess it makes sense. All right, items 4 to 7 are police reports. Police reports are inadmissible hearsay in Florida. It's unclear whether the defendant believes she can use these reports in her case in chief for a potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by expert is permissible, but it does not make the inadmissible evidence admissible. What a wordy one. Hearing is up right now. Oh, it is? You made it live? Hello. Okay, let me pull up I had it up here. Give me a second. Trial TV. I had it up here. Where'd it go? Trial TV. Is it just called Trial TV? I don't see it. Trial TV Live. Oh, did I forget the live part? Oh, okay. Oh, God. What's up with the audio? Let's hope the audio is a little bit better. I don't know. The audio was a little bit weird for you guys. It was a little bit weird. Is it? I don't know. No. Is it me or what's with the audio? Hold on a second.
Judge, on July 31st.
No, audio works fine. Is audio? The audio working? I'm just gonna put the audio down because there's some weird crackling noise. Oh gosh, It was cracking, but it stopped. Okay. Damn, Mr. James Owen looking like he got a good tan. You going on vacation or something? Okay. Hello? I think this was pre-recorded though. Couldn't we just like skip through this? All right, I will
Do y'all hear me now?
I can hear you. Hello? I've never heard of Trial TV before.
No, we can't hear the judge.
Can't hear the judge.
Do they just stream cases?
I think it's on y'all's end. We cannot hear the judge.
Or are they like local to Florida?
We hear other things.
All right, y'all. We'll just sit here and see what's up. Did today's hearing already happen? There was no live
All right, you want me
stream.
to hold on this end?
Are we trying to watch it right now, I guess? We're on Trial TV Live? I haven't heard of this channel before. What else do they got? Trial TV Live is dedicated to offering clean streams to our subscriber. No
Yes, I can.
commentaries, no commercials, nothing but trial coverage.
Mr. J, if you're able to start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify.
It was private but released afterwards. So for the other hearings or other cases that I've seen, usually it's like judges won't allow you to live stream the Zoom call, the Zoom link, the webinar, whatever the fuck you want to call it. But I remember what other like Court TV Law and Crime, what they'll do is they'll have, because they have permission to, they'll record it, and then once it's done, the judge will give them permission to post it afterwards. So I'm assuming that's the case here. Trial TV may have recorded it and then maybe gave the media, like, hey, you guys can release the footage after the hearing is done, I guess.
But is only being offered in some kind of advisory capacity, and all efforts to depose Dr. Brannon have not borne fruit yet. You could pick up where you've left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity.
Can you guys hear the audio okay? We're missing a little bit of it.
So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr. Birkeland, is Mr. J's
Audio is not the greatest. Let's see.
position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all next week. I can do it at any time. The only two things I've got is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant, Sarah Boone, on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week, I would assume. We just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require the production of a report?
Under 3220F, you and your discretion could order it to speed these proceedings along so that I do not have to engage in a fishing expedition.
I think the judge already denied that motion. The state had put in a motion for the defense's experts to give them reports before the trial starts, and I saw the judge already denied that a couple of days ago.
Or in the inordinate amount of time on the eve of a trial that is set to occur on October 7th, when I am unavailable on Friday next week due to an insanity placement hearing in Osceola County that has been previously scheduled and rescheduled numerous times.
Is that the tornado warning sound? Can you guys hear okay? I have it boosted up pretty high, but let me know how it is. I don't know.
I am not opposed to working on Thursday, but Thursday is a court holiday, so we would have to make arrangements. And then Wednesday,
If there are other persons in the media who are appearing virtually to observe this proceeding, I need you to mute yourself, please. There's an individual by the name of Lou. Sir, I need you to mute yourself in order for the court to conduct its business.
Oh no. There's no death penalty for Sarah Boone for this one. She's just facing life in prison. Hey, Nacho.
Whoever is participating in the hearing this afternoon, whose name is Lou, if you can hear me, this is Judge Kranick. I need you to mute yourself, please.
You know, usually the person who's in charge of these meeting rooms, can't they mute these individuals? It sounds fine? Okay. All right. Hi, lady. Oahu. What's up? Okay. People tell me I have an evil laugh.
Mr. Owens, how are we going to be able to coordinate this step? Well, let me hear from you. Let me go back to you, Mr. J. 3.220F says, on a showing of materiality, the court may require such other discovery to the parties as justice may require. Is that your position that allows me to provide written reports?
yes, it is within the court's discretion to order an expert who has not produced a written report, nor have I gotten his CV, to produce a report in efforts to coordinate discovery with opposing party.
Mr. Owens, what's your response?
Judge, my response is it's a narrow issue, battered spouse. Dr. Brandon is an expert. You know, I've mentioned him 2 or 3 times. He testified in the Marsha Thompson case in Palm Beach County. That's his field of expertise. It's not going to be a fishing expedition in his deposition. It's going to be related to that sole issue, battered spouse. And I'm available Thursday. I realize that's a holiday, but I'm available as well. I can make him available. I'll do everything I can to set the deposition as soon as possible.
Do we know of Dr. Brandon's availability?
I can try to get him on the phone now, Judge, if you'd like me to.
Any objection to doing that?
Dr. Brandon's phone number.
I don't want to burden the court. Judge,
Mr. Owens.
I have a pool camera in here. There is no need for anybody else to be on the line except for Mr. Owens.
I can't control that. The media reached out to court admin today and said they were going to appear virtually. I'm trying to log into my app to silence this other person.
I'm having difficulty.
I'm with you on the difficulty scale, and I sympathize with it, but I don't have the ability to remove him at this time. I'm working on it right now.
That's what someone wrote in my Discord. Someone said the judge left and then the meeting kind of just ended. So I don't know if this is like after that happened or if it's about to happen. But I'm sure Court TV will post their version, and then if we missed anything, we'll watch the Court TV version.
If he's available on Thursday, then that will be our preference, because it's my preference to do it in person.
Fine. That will be an in-person deposition no later than Thursday of next week, the 3rd. If you are unable to have that deposition coordinated, you need to let my office know immediately, and we will set a hearing as necessary. I'm in trial next week, but I will make the time in order to make that happen.
He is living or working as listed on the witness list in South Florida. So under the rules, the deposition should have to occur there, unless Mr. Owens is requesting a different location.
Mr. Owens, are you requesting a different location other than South Florida, which is the location of Dr. Brandon?
Well, we'll ask Dr. Brandon, but if he's willing to come up here for the deposition, I'm fine with that. Or we can travel, whatever. We can do it by phone or Zoom. I'm available, like I said, all week next week. I'll do whatever is necessary to get the case resolved.
It's going to be an in-person deposition, so the issue is simply location, whether it's in South Florida where his office is or here.
Doesn't matter to me.
Okay, then you've got your deadline by next week, Thursday, to take that deposition.
Okay, that was in the court minutes.
I have reviewed the state's responses to multiple matters, including the amended exhibit list and the second amended exhibit list, and a response.
Yeah, I hear there's some areas that has really bad flooding. River down the road flooded and like ruined like 20 houses. Jesus. And I bet you, because you guys are probably like in an area where like a lot of hurricanes happen, there's probably no like flood insurance available, right? Like in California, you know, they don't offer earthquake insurance because, you know, they know that earthquake's gonna happen. And hi, Tiki. Tiki, look at that little, is that little cute chihuahua? Tiki, thank you so much for the 20. Oh my God, thank you so much for the super. Thank you, thank you.
that the state had filed regarding a second motion. Was there a second motion to suppress that was filed?
Judge, they filed a notice of objections to the state's evidence late last night. Contained within that objection to the state's evidence was basically an unfiled, legally insufficient motion to suppress statements based on a statement made to a patrol deputy prior to the first statement to the detectives in an unmarked patrol car on February 24th, 2020.
Okay. I have not seen that hasn't cleared the court file yet. I don't believe.
No, I haven't seen that one.
Judge, I believe I sent it directly to your JA. Defendant's objections to plaintiff's exhibit list.
I haven't seen it yet.
Barrios would have been sent to Miss Barrios.
Judge is gonna try to look for it. The flooding was so bad, your office is closed today. I feel very lucky that our house wasn't affected. Dude,
Mr.
water
Owens,
damage
the
sucks.
second paragraph of the second page of the objections seemingly refers to a different interrogation than what is made reference to in your motion to suppress of September 24th.
That's correct.
Okay.
Okay.
May I be heard?
You filed your objections. As of right now, there's only one pending motion to suppress. Is there
That's
another
cool.
motion to suppress that's going to be filed?
I'm not sure, Judge. I had some time constraints on filing this defendant's objections to plaintiff's exhibit list. I put those last two paragraphs in page 2 on there for the purpose of preserving that issue because my client asked me to. Whether or not I'm going to file those or not is an issue that will be decided on Monday when I drive down to speak with her.
That's a good question. I don't see Sarah back there. Maybe she's on the left side. She might be on the left side writing or something.
I may or may not file those, but I wanted to preserve my potential issue. Object.
Did you miss anything? Not really. Oh no! You're muted! Mr. Owens, you're muted! What in the tarnation is going on here? All right, let me just refresh the court's website while we're waiting. Is there anything else that they filed? Let's see. They have a hearing on 10/2. That's
Mr. Owens,
next
can you hear us?
Wednesday.
Cannot hear you, sir.
Can you hear me now?
Yes, sir, we can.
I'm sorry. That was my error.
What if any response do you have to? My concern is I don't have a complete picture of what is attempting to be filed, and you're telling me you're not going to be able to know until you meet with your client on Monday as to whether or not you're going to file a motion to suppress. We're rapidly proceeding to trial in this matter.
I understand that, Judge. I had a deadline for filing these defendant's objections to plaintiff's exhibit list. Based on my last discussions with Ms. Boone, she expressed concern about those two statements that are on the second page, the last two paragraphs. I simply was preserving the right to make an objection on the two exhibits, which is the body cam of Deputy Rodriguez and the audio tape that was taken, the interrogation that was taken in the squad car by the two homicide detectives. I don't know whether I'm going to even file a motion to suppress on those two paragraphs on the second page. I plan on driving down Monday. I will see her Monday night. We'll make a decision at that time. But I felt like I had to preserve that issue in this objection of these exhibits.
Right? Yeah, I'm going to hear that. Because we can't get into a private Zoom meeting. They're not going to let us into the Zoom. Because there was somebody that said they had a Zoom.
What the fuck is
I
going
don't know
on?
who that is.
Can't we just do the old-fashioned way? Counsel can call by phone.
Can we pull him in to, can he call over the overhead? Yeah. All right, Mr. Owens, we're going to give you a phone number to call in, sir, because there are so many people that are trying to...
All right, I think they're about to cancel the Zoom meeting. I mean, honestly, I couldn't even get in the Zoom meeting at all to take a look at it. It seemed like it was like a private Zoom meeting. How are other people to get in?
Participate virtually.
Unless they're part of media.
Okay.
The clerk is going to call you right, sir.
Okay.
Let me pull up this
I think that's it. We missed a chunkling of the beginning, and then it's gonna end early because people don't know how to mute themselves. All right, so the judge is letting the defense to file their motion to suppress by the end of today, 11:59 deadline. I wonder if he's going to be able to meet with Sarah Boone today then, because he says that he wants to meet with her, or he gets to meet with her on Monday. Maybe he wasn't able to get in earlier or something. Or maybe now he can get in earlier and talk to Sarah Boone. Good luck. All right, what else is there? They're going to depose Dr. Brennan. What was I reading? I think I was reading this one, right? Now I gotta read it all over again. People can't figure out the dang mute button. This is kind of like the Alexi Treviso Zoom hearing. People were going on there, they were trolling, but at that one, they were muting the judge, the attorneys. It was way worse. This is awkward. Weird Zoom. Yeah, Mentor. Hi, Moondog. How are you doing today? Hello, Posey. Okay, so I think that's it. I don't think anything. Okay, I think this is what people meant by the judge and everyone left the Zoom, and then they're gonna call in. Oh, well, maybe we could still hear from his side. Maybe he'll just leave this thing up while they call in. Just said, hey y'all, can you keep an eye on Mr. Owens for me? Mr. Owens looks like he's got a nice little tan right there. All right. Well, let me refresh Court TV. See if Court TV's got anything. I don't think Long Crime has been streaming in any of this live, right? So everyone, how's your day going? How are you doing? Well, while Mr. Owens is working, I'll read you guys this motion. You guys ever heard of co-work? Where you'll have a stream that's up and they're working, and then people or the viewers will just work alongside them? No, this isn't the judge. This is James Owens, the ninth attorney. All right. I don't know if we're gonna hear anything else. Okay, I'm gonna go back to rereading this. The state's preliminary objections to the defendant's amended exhibit list. 1. September 26, 2024 at 7:21 p.m. The state received an amended exhibit list from the defendant. That was yesterday night. Number 2. This is outside the scope of the time frame the defendant was allowed to list exhibits, but the court granted leeway for potential extension. Number 3. The potential admissibility of battered spouse evidence has changed the feasibility of all the court's deadlines in a scheduling order from August 5th, 2024. Number 4, items 1 through 3, which the defendant does not even have yet, will likely require hearsay relevance and 90.403 objections to be made, resulting in either their exclusion or voluminous reductions to be made. Also, these records may require the battered spouse syndrome experts to have to re-examine the defendant and potentially be re-deposed. Number 5, items 4 to 7 are police reports. Police reports are inadmissible hearsay in Florida. It's unclear whether the defendant believes she can use these reports in her case in chief for potential rebuttal. The latter may provide some limited admissibility. Reliance on inadmissible evidence by experts is permissible, but does not make the inadmissible evidence admissible. So, Sarah Boone wants to, this is what I think. They want to have other law enforcement that responded to the scene when her and George were fighting, and they probably wrote police reports about what happened. You know, maybe the bruises on Sarah, bruises on George. And did I say Juan? Hold on. George. Did I say Juan earlier? Okay, sorry. I don't know. I feel like I caught that way too late. Anyways, George, when they were fighting. And so when the defense put in their list of witnesses that they're going to call up, a lot of them were law enforcement, and then there was a Brian Boone. And I was assuming law enforcement because, you know, law enforcement, they went to the Sarah Boone apartment so many times because they were fighting back and forth. People called, put the police on them. Maybe they called the police on each other. And so she probably wants to use her police reports to use it against, the victim, George, here. But if you guys remember in the Karen Reed case, where the jury wanted the police reports. No, they didn't want the police report. It was like, they wanted the ARCCA report or something like that. And for me, I like reading reports, but I didn't know that, usually reports aren't given to the jury as evidence because the reports are usually considered hearsay. And if I remember correctly, they were able to use reports to impeach someone testifying on the stand. So, for example, if you have like a Jen McCabe going up there and she says something, and then they can use her, report that she gave to police against her, like, oh, hey, you're testifying this right now. However, in the police report, it said that, you said this instead. This was your statement instead. So that's what I remember about these reports. All right, number 6, regarding items 8 through 11, the state notifies the defendant that it will potentially use photographs of George Torres' injuries as well. This will also involve the testimony of the deputies who observed George Torres' injury during these prior incidents. Number 7, item 12 includes inadmissible hearsay from the defendant. Number 8, item 13 is inadmissible character evidence, Florida Statute 90.404. If the defendant does testify that she used justifiable deadly force against George Torres on the evening she killed him, she is permitted to testify to prior acts of violence committed by George Torres that she is aware of. This, however, does not allow a rap sheet to be admitted into evidence. Number 9, item 14 is another police report, which is inadmissible as explained above. Item 15 is inadmissible character evidence. The attacks on the decedent's character is a self-defense case are limited to reputation for violence evidence and specific acts of violence which the decedent committed that the defendant was aware of. Number 11. Item 16 is irrelevant and likely filled with hearsay. The state has not been provided this information. I thought James Owens was supposed to call into the court line. What's going on here? Is he not going to call in, or are they supposed to call him? Number 11, item 16 is irrelevant and likely filled with hearsay. The state has not been provided this information. Number 12, 17, 18, irrelevant, inadmissible. Geez, they're just like steamrolling through all of this. 13, 19A-O are inadmissible hearsay. In the 911 call, the undersigned has heard from June 18, 2019 and September 4, 2019. The defendant makes it clear to the dispatcher that it is not an emergency, and these statements are not excited utterance. They are merely inadmissible, self-serving hearsay. The remainder of the calls are not potentially relevant to this case until the defendant alleged the relevance of battered small syndrome evidence and have not been reviewed by the state. 14. Item 20 does not appear to be relevant other than showing that the defendant had no injury. 15. Unless otherwise noted below, the state does not have any preliminary objections at this time to items 21 through 51, without waiving any potential objections that the trial develops and not waiving the predicate for the photograph movie being required prior to these items being admitted to evidence. And then we have a bunch of them that are irrelevant, duplicative, admissible, inadmissible hearsay, inadmissible hearsay. So these are all the objections by Mr. J. Lots of objections here. Here's another one by the state. State's objection to defendant's Second Amendment reciprocal discovery exhibit list. Okay. Oh, wait. Nope, that's it? I think that's it?
They ended it.
All right, that's it. Okay. Yeah, I'm sure the media, wait, let's see. Hold on. Ooh, latest news. Hold on. Maybe I've got something. Give me a second, y'all. Do we have something here? There we go. You know what? I knew we should have just been a little bit more patient. There we go, y'all. Here we go. Sarah Boone's here. Hi, Sarah Boone. We got it. I can't boost the audio on here, though. This is the Court TV's website. And I don't know how to get rid of this damn ad. How do I get rid of this damn ad, y'all? Tell this ad to go away. Go away. I don't want this. What is this? Rug Adventures? No! Go away. How do I make it go away? Oh my god. The ads on Court TV are so aggressive. Jesus. Okay. I give up. I'm gonna... Now it wants to sell me a Hydro Pro rower. Oh my fucking god. Report the ad? Where? I just want this. Okay, hold on. Let me give me a second. Give me a second. Okay, I got this. Okay, I got this. All right, this is what we'll do since the fucking ad won't go away. Holy. All right, I'm gonna reposition this one. Okay. All right. Hi, Judge Kranick. How are you doing today? Okay. There you go. You guys don't have to suffer and see the ad. The ad is still bright and white on my screen. There you go. Okay. Now, I hope the audio is good because I can't boost the audio on here. At least it's not the anime websites. Oh, with the little jiggly boobies. Busty blondes in your area.
Judge, can you hear me? Loud and clear, sir. Can I get your appearance for the record? Date of birth for the record for me. All right, we are here on...
Can you guys hear? I gotta put my other earbud in.
Trial case management. In this case, I know there's been some activity over the last couple of days in the court file and correspondence between Mr. Owens' office, my office, and the state attorney's office in attempting to coordinate some hearings. The first item on the court's list is whether or not the examination of the defendant took place as ordered in the court's September 20th order.
Okay, I'm gonna adjust the audio accordingly. Oh my goodness.
Okay, when do we believe we're going to have the opportunity to have that examination by the expert of the state's choosing?
Wednesday, October 2nd at noon.
Okay, and has that been cleared with everyone's calendars? Mr. James, Mr. Owens, is that accurate, sir?
That is, Judge, I can't see my client. I don't know if that is an issue or not.
All right, I'm sure they'll fix audio soon.
He's on the far right-hand side of the box.
I see you, Judge.
Okay, very good. All right, so that examination is taking place on October 2nd at 12 noon. The next item that I have on my list is depositions of the recently appointed experts for the defense. I know Dr. Harper's deposition is set to take place on October 1. With regard to Drs. Brennan and Birkland, are those depositions in the process of being scheduled?
Oh, no, it was fixed for a second there.
What's the status on those?
Oh, it's fixed.
I was told by the defense that they're not calling Dr. Birkland. He was only going to be a consultant, so there will not be a deposition of that doctor. The other doctor, we have made attempts to
Doctor who now? Dr. Berkler?
try and coordinate and not gotten anywhere with that. I am not even sure what he is going to do.
Judge?
Hang on, let Mr. J finish his point, sir.
I'm not sure if he's going to be testifying to battered...
Judge? Hello?
Mr. Owens, we can hear you loud and clear, sir.
Judge?
Yes, sir, we can hear you.
Judge?
Mr. Owens, I can hear you.
Oh gosh, the Zoom
I
stuff
can
is
hear
so
you
bad.
loud and clear, sir.
Judge Kramer?
Yes, sir, we can hear you. I can hear you.
I just can't.
Judge Kramer?
Mr. Owens, I can hear you, sir.
Judge Kramer?
I can hear you.
I can't hear you. I can't hear you.
Oh my gosh, I feel bad for Mr. Owens. Tech stuff sucks.
Judge Kramer?
I can hear you. I can hear you. I do not know why you cannot hear me, sir.
Judge?
Oh, poor Mr. Owens.
Sir, can you hear me?
What am I doing wrong? Judge Kramer?
I can hear you.
Someone just needs to call Mr. James Owens. Call him on the line. All right. What a great Friday that we're having, y'all.
Judge Kramer?
Oh, thank Court TV.
Loud and clear.
Court TV always comes through. The carpeting. What's wrong with the carpet?
Judge Crane?
Let's see if I can get him here to call him, tell him that we can hear him.
This is a delay, doctor. Do 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 do. Not delay tactic. Hurricane. It's just tech issues. Oh, I can speak softer. It's because I have the audio at max, but I can't make it.
Somebody from Orlando is calling me.
Speaking of carpet, I went.
James Owens.
Ooh. I went to a restaurant in Hawaii. It was an indoor-outdoor restaurant right by the beach. Hawaii's kind of humid. They had carpet inside the restaurant. I was like, what? Why do they have carpet in here? It was so weird. Got wine spilling, food spilling. I don't know. You gotta clean the carpet like every damn day. All right, I'm gonna put the audio like a little bit higher. Sarah's here. Yeah, she popped in. We're 8:35 right now. Oh, wait, where'd she go? What's it? Oh, she's right there. You could barely see her. She's like right there. You like a smidge of her. She's wearing blue.
Just so it doesn't look a mess.
Do y'all hear me now?
Yeah, James Owens is just having issues with his audio setup stuff.
No, it's, we can't hear the judge.
Can't hear the judge.
Counselor, can you
It's on y'all's end. We cannot hear the judge.
can you hear me at all?
But we hear other things.
Oh, you're cleaning the carpet right now? It's satisfying. There's these channels that do rug cleaning. So satisfying to watch. It's so nasty though, but oh, so satisfying. All right.
Bear with us if we have some technological issues. Just hang on. Just have him hold on your end. Let's see if we can get.
Okay, so Court TV lowered the audio right now because I think they know the audio is really crappy.
Counselor, can you hear me?
Yes, I can.
Mr. J, if you're able to start over and pick up, or rather than pick up where you left off, start over on the issue of, we were discussing the depositions of the recently identified experts. We had confirmed that Dr. Harper's deposition was October the 1st. Dr. Birkeland, my understanding, is no longer being called as an expert to testify, but is only being offered in some kind of advisory capacity. And all efforts to depose Dr. Brannon have not.
You know what? It might be better to wait until Court TV uploads this on their YouTube channel. I don't think they uploaded it yet. Because I don't know if y'all are gonna be able to hear. I have it like max volume on my end. I don't know if y'all can hear.
Not borne fruit yet. You can pick up where you left off.
Yes, we have tried to get that coordinated and have had no success with opposing counsel. I am not even sure what this person will testify about. I don't know if it's another battered spouse syndrome expert. Florida law seems pretty clear that any other mental issues would have to be insanity. So I'm not sure exactly who this doctor is. We had prayed the court for relief and at least getting a report by today from him. We have not gotten such a report. So I don't know when we will be able to coordinate that deposition prior to trial.
Okay. Mr. Owens, with regard to Dr. Birkeland, is Mr. J's position that that person is not going to be called at trial accurate?
That's correct.
Okay, all right. So is there any reason to worry about deposing that person at this time, Mr. J?
No, sir.
Okay. With regard to Dr. Brannon, are you still going to be offering him as a witness at trial, Mr. Owens?
Yes, Judge, and I'm going to be down there Monday night, and I'll be available all of next week. I can do it anytime. The only two things I've got is the Dr. Harper's deposition on October 1 and the state's expert evaluating the defendant Sarah Boone on Wednesday, October 2nd. But I'm free anytime, and we can make Dr. Brannon available any day that week. I would assume we just have to get with him.
Mr. J?
It would be helpful if I had a report so that I could craft a preparation for this person's deposition.
What is the basis to require?
All right, so the other one, Dr. Birkland, was Dr. Birkland the crime scene reconstructionist, death investigator? Was that Dr. Birkland, or is that a different person? So this is the part where it was already covered on the Zoom video that we just watched earlier. They moved on from Dr. Birkland because I guess he's not going to be. Wait, where are my notes? They moved on from Dr. Birkland. I think he's going to be a consultant. That's what they said. Now they're talking about Dr. Brannon. Dr. Brannon is the one who is a... They labeled him forensic psychologist, and then they relabeled him as something else. Maybe just like a psychologist or something. But he was the one that testified in the Marsha Thompson case. And so the state wants there to be a report given to them before the trial starts. The state's like, I haven't gotten a CV from James Owens yet. I don't know how to contact Dr. Birkland. I don't know how to contact him for deposition. And the judge is just asking him, okay, like, why do you need a report? And then the state's explaining their case. And then at some point, the call kind of drops, and then they pick it back up again, and maybe the audio is better.
Require the production of a report.
Under 320F,
Birkland is crime scene guy. Okay, so this part we've already listened to on the Zoom. So I'm going to forward to the part where... I think at this point, there was someone on the Zoom meeting who didn't mute their mic. The judge gives up, ends the Zoom call.
And I'm available Thursday. I realize that's a holiday, but I'm available as well.
Okay, I remember this part. They're trying to figure out a date to meet up together where they can do the deposition of Dr. Brannon.
Under the rules, the deposition.
Because my client asked me to. Whether or not I'm going to...
We're rapidly proceeding to trial.
Dude, I don't know. The audio's just getting lower and lower and lower and lower. I don't know. We might have to watch the court TV version on YouTube later.
In this matter.
I understand that, Judge.
Hey, Dad Bod, how's it going?
In this case, as in every case, which clearly spells out to the defendant that she has to file all of her pretrial motions 10 days before pretrial.
And you're referring about which location?
I'm just trying to see if the audio gets better.
Discovery, just as it relates to the experts.
Okay. Mr. Owens, any response to that?
Okay, I think if you guys have it on max volume, I think you can hear it. Does Rebuttal mess with your hearing or something?
Yes, I can.
All right, very good.
Okay.
All right. State, what, if anything else, with regard to the objections as raised, making reference to another potential motion to suppress?
Wait, oh, that was caricatures? How do you know? Are you making false accusations?
Judge, the state's entitled to pretrial rulings on all of these issues involving constitutional rights being violated. If the court...
No, I don't think Kari was able to get in. I think she was trying to get in, but I don't think she was able to get in, though.
gives the state an adverse ruling, we need the ability to file a petition for a writ of certiorari because we do believe these statements are crucial to the case. And as I outlined in one of my responses that I filed today, there is a uniform pretrial order that was issued in this case, as in every case, which clearly spells out to the defendant that she has to file all of her pretrial motions 10 days before a pretrial conference and get them heard. And here we are at the time of the pretrial conference, and we're still kicking this can down the road as to whether or not we kind of maybe sort of might file a motion to suppress. And so we're just asking for them to file it, and if they're not, then perhaps we will do something so that we can get a pretrial ruling on the constitutional admissibility of these statements so that there's not an adverse ruling during trial which the state can seek no relief from. I don't think we're asking for much. It's been over 4 years. She's been well aware of her statements. She's gone through numerous counsel. It's not unfair to ask the court to get an answer. Are we going to do this? Because if so, when are we doing this? We can't do it next Friday. We can't do it next Thursday, as far as I know, unless you can get Judge Munyon to open up a courtroom. And then we will have to deal with, are we in South Florida? Are we doing a deposition of this late expert? What part of the day? And then Wednesday, we already have the bulk of our middle of the day consumed by going out to the jail, which will probably take from about till 10 a.m. till 3 p.m., going from travel from here, getting through the screening process at the visitor's entrance.
She laughing at Mr. J. Is she making fun of his logistics? For reference, I have no idea what Mr. J is arguing about. Maybe they're talking about the deposition of this expert, and then they're trying to coordinate a day or time, and it doesn't work out. And I think that's what they're talking about.
And getting back to the female dorm, and then reversing that process. And then we have the deposition of their expert on Tuesday. So we're kind of running out of time to do these things and to coordinate and make sure that the two detectives and now potentially this patrol deputy have availability when they were never asked to be made available next week. They've been asked to be made available for the 3-week trial period. So I don't think we're asking for much to just get an answer. Are we going to do this motion to suppress? And if
Thank you, Nerdy. They're talking about the potential motion to suppress. They're stating if they're not going to. Oh, okay. That makes sense. Okay, because Mr. Owens was like, hey, I'm going to meet with Sarah Boone on Monday, and I think I can probably, from there talk to my client and then do the motion to suppress. And the judge was like, and the state's like arguing about that, saying that that's a little too last minute. Time frame's not going to work for us. Okay. Time crunch. Gotcha. Thank you.
So when we already have a motion to suppress issue to deal with the 2-hour and 6-minute interrogation, which is going to take probably about 4 hours between testimony from the witnesses, the court watching the full 2-hour and 6-minute interrogation, and then arguments of counsel.
Anything further, Mr. Owens?
Even with my motion to suppress statements, I don't think it's going to be necessary for you to watch the 2-hour and 6-minute interrogation on that issue about whether or not the court should grant my motion. Again, on the issue of the pleading that I filed regarding my objections to the exhibits, it's the same response I gave before. I essentially felt like I needed to file them. I don't know whether or not I'm going to file any motions to suppress on on the Deputy Rodriguez's body cam. I'll know Monday night. I don't know if I'm going to file a motion to suppress on the interrogation in the squad car. I'll know Monday night.
Okay, so he says he doesn't know if he's going to file a motion to suppress for one of the officers' body cam footage, and then doesn't know if he's going to file a motion to suppress for the interrogation video in the car.
Simply preserving that issue, that we wanted to object based on that. We're working as diligently as we can. I understand.
He's working diligently.
Boone has had the case for 4.5 years, but I have not had it for 4.5 years, and I'm doing the very best I can to comply with the court's order to be ready for trial October 7th and still protect my client's rights as I see fit.
You're going to have till today to file that motion. You can buttress it, you can amend it, you can provide case law. The only thing I'm going to ask is that you provide the court and state attorney's office any case law that you plan on relying on, but you can always withdraw it if you need to after your conversation with Ms. Boone.
All right, would you clarify that again, Judge? So I've got until
the end of today.
The end of business today, or the end of the day?
Any responses to that, Mr. J?
The end of today.
It makes no difference to my weekend at this point, Judge.
Okay. You'll have till the end of the day, sir.
Mr. J says it makes no difference to my weekend, Judge.
No later than 11:59 tonight to file that motion if you're going to file it, because the state needs to be advised as to
Excuse me, Judge. Did you mean East Coast time or West Coast time?
what, if any, positions you have with regard to those matters.
Are you referring to the motion to suppress the statements made during the body cam of Deputy Rodriguez, and then a separate motion to suppress any statements made on the audio tape of the interrogation by the two homicide detectives in the squad car? Am I correct?
I am referring to the paragraphs that are in your objections. Second page, first paragraph, and second paragraph.
Yes, sir. I understand.
If those are filed and when those are filed, I need you to favor copies to my office, please.
Yes, sir.
Now, regarding the motion to suppress that was filed on September 24, I understand next week's very busy. I know that my office had inquired if anyone was available Friday. I now understand the specifics as to why Mr. J is unavailable on Friday. As the parties are aware, the court, this is not the court's only case. The court is in trial next week. We have a legal holiday on Thursday. I don't believe that Judge Munyon has the ability to open up the courthouse just for me, as this is a statewide court holiday. That would be required of the Chief Judge of the Florida Supreme Court, I think, to make that decision. And I don't know that I have the ability to call Chief Judge Muniz to get that decision by Thursday to allow us to conduct work on that time. I will make myself available next week, but the problem is the scheduling of it, because the court is in trial, and the state certainly deserves an opportunity to understand the court's ruling prior to trial in order to prepare what, if any, rulings would be adverse or for the benefit of the defense or for the state. I don't know, because I haven't had the hearing. With regard to the 4 hours, Mr. J, why could I not review that 2-hour and 6-minute interrogation prior to the hearing, such that we would be able to save some level of judicial efficiency and economy?
I have no objection to the court doing that. I just understand that some judges in this building do not do that.
I don't have a problem looking at it in advance, and that way if there are certain things that either yourself or Mr. Howens wants to highlight for me during the hearing, look at time step X or Y, certainly I'll give you both the opportunity to
Don't worry, Judge. We'll watch the interrogation video with you. Gotta watch it this weekend, I think.
do that. But I think for judicial efficiency and economy, I don't have a problem reviewing it so that we don't have 4 hours of hearing time. Maybe we limited it to 2 for the purposes of case law argument and any testimony.
Judge, if I may,
Yes, sir.
if I may, Friday, I know there's two prosecutors on this case. I understand that this prosecutor is going to be elsewhere, but the main prosecutor who's prosecuting this case that would be available Friday for a hearing on this issue about my motion to suppress.
I'm handling the motion to suppress issue.
Okay, that answers that question. Mr. J is handling it. So I am here at your disposal, gentlemen, for when we might be able to set this motion for hearing.
What day?
Judge, if I may, we've been in contact with Dr. Brandon, and he is available on October the 3rd at 3 p.m. I'm just waiting on a location from him, but I believe that. Judge, that's Thursday at 3 p.m. That's the holiday. So I'm available that day. We just got to check with Dr. Boone about which location, whether Orlando or South Florida, where his office is.
State's not willing to go to South Florida for a 3 p.m. depot on Thursday
State's not willing to go to South Florida for a 3 p.m. depot.
when I need to be ready for back in town and get a good night's sleep before doing the insanity place
He needs to get a good night's sleep, be back in town for something.
Friday morning. So
Friday morning.
not willing.
Mr. Owens, hang on, please.
Not willing to do it up here, then we'll need to coordinate another time during the week.
Okay. 3 p.m. is not going to work based on the state's schedule and what they have to take care of on Friday.
Okay, I'll try to get him up here for that date and time, October the 3rd at 3 p.m.
Are you stipulating?
I'll tell you everything.
Are you stipulating then, Mr. Owens, to having Mr. Brandon appear in person for the October 3rd at 3 p.m. deposition here in Orlando?
I I can't stipulate without talking to the doctor first, but I'm going to make every attempt to get him up here. But I'll let the court know, hopefully this afternoon, and the state know this afternoon.
Okay, all right. Getting back to the September 24th motion to suppress. State, how can we tee this thing up for hearing in time, understanding that you're out of pocket on the 4th?
Judge, I'm available Monday. It's my understanding that opposing counsel will be in transit to the Orlando area on Monday, so I don't know of his availability. On Tuesday, we are taking the deposition of Dr.
Yeah, they said Dr. Dr. Berklin's going to be a consultant. State says they don't have to worry about deposition. And then they're talking about Dr. Brandon, trying to get his deposition because state wants to know, well, what is this doctor going to say? Dr. Brandon. There's so many B's here. Is Dr. Brandon going to say that, Sarah Boone is also a battered spouse? Like, what's up?
Dr. Harper from 10 a.m. until I'm concluded with that deposition. But we should have afternoon time, especially if it's only going to be 2 hours on Tuesday the 1st. And on Wednesday, I can make myself available to do it at 8:30 in the morning with the court prior to us getting ready and going out to the evaluation at the jail. Or we could do it afterwards at 3 p.m. on Wednesday when we are done at the jail.
But 3 p.m. is when the evaluation concludes, correct?
She says 2 hours, but what I'm trying to include into that is leaving the female dorm, getting back to our cars, driving up I-4, getting to the courthouse.
Okay, so that's a 3 p.m. ETA here.
Yes, sir.
Okay, got it.
Judge, my only concern is I know the two homicide detectives, I anticipate the state being able to have them available whatever day, but I do want the custodian of the records to bring from the sheriff's department, so I have to subpoena them to bring the policy and procedures and the Miranda card and the waiver of rights form under the Miranda.
Any response to that? Okay, all right.
Has Dr. Brennan even interviewed Sarah? I don't remember hearing about that in any of the previous hearings or any of the court stuff filed. I don't know. I know Dr. Julie Harper met with Sarah recently, but I don't know if Dr. Brennan did. Maybe?
We'll make it happen on Wednesday. I'll advise the ASA.
Because I remember when the judge granted JAC to pay for the fees for Dr. Brandon, at that point, he didn't have to do, what's it called? Pro-nunc-tunc? I don't know what the fuck that phrase is. But I think it means that, like, oh, if they did work for someone, then you could pay them in retrospect. But I don't think there was any work done between Dr. Brandon and Sarah Boone yet, because the way the judge phrased it made it seem like they didn't meet yet.
In the defense in the trial that's set for Monday, that
Was it
we're going to have a hard break at 3 o'clock on Wednesday.
pro-nunc-tunc?
If we have to work a little bit after 5 o'clock, I will let my court staff know that we may have to work a little bit later that evening.
Pro-nunc-tunc is a court order that retroactively corrects a previous ruling or decision. The term nunc-pro-tunc is Latin for now, for then. See, I didn't study Latin in high school. The purpose of nunc-pro-tunc is ordered to ensure that official record accurately reflects what happened, even if there's an error or an oversight.
In order to make that hearing happen, State, are you going to be able to subpoena your witnesses in time to get them here?
They will come.
All right. Defense is Wednesday at 3 p.m. acceptable.
State?
Mr. Owens?
Yeah, I'm here, Judge. I'm sorry.
Wednesday, October 2 at 3 p.m. for a hearing on the motion to suppress.
Judge, I'll work on getting my subpoena out today for the motion to suppress Wednesday, October the 2nd at 3 p.m. Eastern Standard Time.
Correct. At that point in time, we'll also address the motion that was filed at 1:13 this afternoon regarding clothing, etc., for Ms. Boone.
Oh, we haven't read that motion yet.
I conferred again this morning, Mr. Owens, with Barry Click, the Public Defender's Office. She has not heard from you yet. Are you going to be relying on the Public Defender's Office to provide clothing? They are still ready, willing, and able to do so.
No, Judge, we were going to provide clothing for Ms. Boone.
Okay.
Why is she laughing?
We wanted to get out there one day. early, Tuesday probably, to take measurements from her.
That's something you're going to have to address with the jail.
Okay.
I know I saw your motion. I don't even know if the state's had the opportunity to review it yet.
I have. I believe the shackles portion of the motion has been a ship that has come through here and sailed, and I believe all the clothing issues have been addressed.
Oh, I didn't know they had closed captions. Thank you. Sorry about that.
Addressed by the court. The only thing that seemed to be new was the hair and makeup, and I did not see any authority cited that specifically said that was permissible. But we don't really have a dog in the fight. If court admin and security staff, however it works, is going to permit this to perhaps, as far as I know, be the first person to ever have that done in this courthouse, that's between them.
Okay, all right. So the court will review that motion and the case law that you provided for me, and I will make a ruling on that in chambers as soon as practical. State, is there any other housekeeping matters or anything else from a scheduling perspective we need to address today?
There just appears to be a lot of discovery that is still outstanding, and that discovery includes medical records from several different locations, and things, those specifically, and perhaps other things that are probably pertinent to all three of the experts, the two defense and the state's expert on battered spouse syndrome. So I don't know how we want to handle that, because if this information finally does come in, and again, I believe the court has already accepted the state's arguments that once jeopardy has attached, then it's too late. But there comes a point in time where it's too late for us to get this new information to all three experts and then redepose them as well. So there is my concern with this outstanding discovery, just as it relates to the experts.
Okay. Mr. Owens, any response to that?
Judge, we'll call today to see where, if the medical records are en route. We'll get the state an answer today, one way or the other.
Okay. Get the state an answer today, one way or the other. But if it's Friday next week and you get them, that could be problematic as to whether or not they're going to be permitted or not. I'm not saying yes, I'm not saying no. It's just the closer we get to trial, the limited opportunities we have for everybody to understand what those records are.
Judge Clayton, we're doing the best we can.
I understand that. Anything else from a scheduling perspective, state? Mr. Owens, anything from a scheduling perspective from your side of the ledger?
I don't believe so.
Okay, all right.
Hey, Kova.
Are there any other matters with regard to?
I need to use the bathroom real quick. Give me a second. We got another 4 minutes left, and then let's read in all the new stuff that's uploaded on the website. Ooh. You coming in, Cheryl? What? Oh, you're summarizing medical records right now. It takes so much time. Sounds time consuming. Hey, Rachel. I do. He's right here. He's right next to me. We need a shot every time he says he's doing his best, the best he can. You know, sometimes Owens reminds me of Elaine, just a tiny bit. Just a tiny bit. A little tiny bit.
The trial that we need to address starting on October 7. Jury selection is going to be here in 12 Alpha.
Hi,
I
Crollo.
outlined previously the amount of people in working with jury services that I'm going to be bringing in. The court's druthers are in the morning to have 50 people, address any preconceived notions or knowledge about the case, and cause challenges as to our jury sacrificing 3 weeks out of their life to come participate in this process. And for those that may be able to do that, I will give them a number, or Madam Clerk will give them a number for jury services to call for when they're supposed to return. I then intend on having another panel of 50 at 1:30 that afternoon. That will continue until we have a panel of 40 to 50 persons for which to select our jury from. Does the state have any questions with regard to that process?
No, Your Honor.
Mr. Owens, do you have any questions with regard to that process?
Judge, are we going to be in a bigger courtroom than the one you're in now?
No, sir, but we can fit 50 people in here. In the gallery, I can fit 50 prospective jurors. And I've already coordinated with the sheriff's office to ensure that we'll have the appropriate number of seats in order to make that happen.
Okay.
So any questions with regard to that protocol?
No, sir.
Okay. All right. Anything else that we need to address, state, from your side of the ledger?
Just that based on the battered spouse syndrome evidence, we are, as well as the defense, working hard to get everything in rebuttal put together for that. I believe they have listed all the patrol deputies for the prior interactions that the defendant and the victim had in this case. We're going to be listing those as well. So I don't think that would constitute any surprise or great shock. But other than that, I think that's all the state has.
Okay. All right. Anything else we need to address from your side of the ledger, Mr. Owens?
Just some discovery issues, Judge, but I think we need to deal directly with the state on those.
And discovery issues, what are you referring to specifically, just so that I'm clear?
Well, there's a public surveillance video from Publix that we cannot get to play. We received it from the state, but we requested new videos or a specific program, but it will not play for us.
A public surveillance video from Publix, the grocery store? Did you download VLC yet, Mr. Owens?
I assume that's the one either where Sarah Boone and George Torres were going to Publix the first time, and there was a second time that just George Torres went. So we're trying to get that. I think we're trying to get an updated address on Melissa Sexton, which is a witness and I think is listed by both the state and the defense.
Melissa Sexton. Wasn't that the same name as one of Amber's witnesses, Amber Heard's witnesses, Melissa Sexton? Was that her acting coach?
And then we have an address for a Deputy Zito that's a P.O. box. We probably need a better address from that. So just as
Oh, is that the property manager? Okay, maybe that's why I heard it.
that the state and I can get together and try to resolve.
Okay. All right. Anything else, state?
No, Your Honor.
All right, Mr. Owens, anything else?
I don't believe so, Judge. We're going to do our best this week to get all this resolved and be ready for trial October 7th.
Okay. We will see you next week on the 2nd at 3 p.m. for hearing on the motion to suppress, filed September 24, and for trial on October the 7th.
Wow.
With that, court will be in recess. Thank you all very much.
Thank you, Judge. Bye-bye.
Okay, well, we'll wait until she leaves the courtroom. I know you guys like watching that part. Sometimes I end it too early, and you're all like, wait, let's watch her leave the courtroom. I think her hair looks fine for trial. I don't know what they can make. Like, how can they work with that hair to make it look better? It's not like they're going to waste any money on, like, coloring and highlighting. All right, there goes Sarah Boone. So, today's hearing was pretty chaotic. Very chaotic. Thank you, Court TV, for uploading this. Let me switch back to the usual. I don't know how to get their ad to go away. Okay, so let's refresh the court's website. Give me a second. How's everyone doing today? Paper brown bag. I think her hair looks fine. Just put her in some clothes. I don't think she even needs makeup. Maybe give her a pair of like fake glasses. You know how they love doing that. Do the Jodi Arias thing. No, actually, no. I think Jodi Arias wore real glasses, right? She was like, she realized when she was in custody that she needed eyeglasses because she had bad eyesight or something, and she didn't realize it before. Okay, what do we have? Notice of hearing. All right, just to recap again, I've already did this in the beginning of the stream, but we'll do it again. We'll be a little repetitive today. Per the court, the defense must file the motion to suppress by the end of today. So Mr. James Owens was talking about potentially filing a motion to suppress in regards to the officer body cam footage and the interrogation video in the car. I haven't seen the interrogation video in the car yet. I've just heard the audio. We listened to it about 2 days ago. That's posted on the YouTube channel. Court minutes. The court will rule on defense motion as it relates to hair and makeup in chambers. Oh, yes. Let's read that motion. And then the court minutes, the state to depose Dr. Brennan in person no later than Thursday, October 3rd, 2024. We were in the middle of reading. Let's see. We were in the middle of reading. Which one were we reading? We're reading this one? Shit, I don't remember. Was it this one? All right, we'll go backwards. State's objection to defendant's Second Amendment reciprocal discovery exhibit list. Number one, the state received the Second Amendment exhibit list at 10:44 p.m. on Saturday or September 26th. So yesterday night at 10 p.m. God damn. Number two, the only apparent change was adding item 13, jail phone calls. Hold up a second. We got some jail phone calls now involving the defendant and third parties when received. Jail phone calls between Sarah Boone and who? While the state may introduce statements of the defendant as a party opponent, the state is strongly see any hearsay exceptions which would allow the defendant to introduce any jail phone calls. Wait, why is wait, what? They want to introduce, why do they, what could be on the jail phone calls that would be good for Sarah Boone? Is it going to be like phone calls between Sarah and her friend saying that like, oh my gosh, I knew you've always been abused by George. Those kind of calls? I don't know. How could that help her? All right, state's response to the defendant's objections to plaintiff's exhibit lists. 1. On April 13, 2020, the court entered a uniform order setting pretrial conference and trial. 2. Part 1, 4B requires the parties to file all her pretrial motions 10 days prior to the pretrial conference and cautions that late filing of motions to suppress may result in denial without a hearing for State v. Powell. Number 3, defendant has had copies of the statements she made to law enforcement for over 4 years. Number 4, now at 11:43 p.m. last night, the evening after her pretrial conference was scheduled, files a legally insufficient motion to suppress her statements made to Deputy Kayla Rodriguez. Oh, we like Deputy Kayla Rodriguez. I think Deputy Rodriguez was the body cam that we were following around when we were at the scene. And the first 2 statements made to Detective Colpsel and Lowen. This comes on the heels of another delinquent and legally insufficient motion to suppress statements filed on September 26, 2026, 2 days prior to the pretrial conference. It is unclear why these statements were not made part of the motion to suppress filed on September 24, 2024. And then also remember, yesterday was supposed to be the actual court hearing. So technically, because of the hurricane, Owen's got like a little mini extension, but man, filing it late last minute like this? Number 5, the court should require the defendant to file a proper motion to suppress so the state can enjoy a pretrial ruling, on the motion, and the jury does not have its time needlessly wasted. All right, we got a Microsoft Word doc. Who uploaded this Microsoft Word doc? Defendant's motion for a right to hair, cosmetic, civilian clothing without restraints for trial. Comes now the defendant by and through the undersigned counsel, moves this honorable court for an order permitting defendant to appear in all court proceedings pertaining to trial in civilian clothes without restraints instead of a jail uniform. I agree with that. In addition, the defendant requests that she be permitted to have a right to having her hair styled and access to, is that a right for court proceedings? A right to have your hair styled and access to makeup? I mean, why didn't Letitia exercise that right? Yo, when she showed up to those to the days of her trial, her hair was looking jacked up. In support thereof, defendant states the following facts. All right, let's see what happened here. Oh my gosh, peach crumbs in the oven. You guys are making me so hungry. That sounds so good. You wonder how much this costs? I mean, she's been sitting there for 4.5 years, going through all these different attorneys. Statements and facts. The defendant is presently incarcerated and scheduled for trial on October 7, 2024. Number 2, defendant has been incarcerated for over 4 years. The defense would like access to professional hairstyling, cosmetics. Yo, take her to Sephora and then go take her to, what's that popular hair salon that people go to in America? Dry bar. All right, someone get her a dry bar person and then take her to the Mac counter. All right, she wants professional hairstyling, cosmetics, and civilian clothing without restraints throughout defense trial appearance and respect for the court and prospective jurors. I've seen oh god, Lori Vallow. Do you guys remember the clown Lori Vallow? Lori Vallow be showing up to these like court proceedings, these hearings in some clown makeup. How did Lori get a hold of that? Did someone give it to her, or did she make it herself in the jail? Because she had like this like red cheeks, some red lips, her eyes be looking kind of weird. I don't know, man. Glamour shots. Number 3, without the court entering an order permitting her access as such, the right to receive a fair trial will impermissibly be infringed upon. I don't know. Hair and makeup? All right, what do we got for a legal argument? A, right to appear in civilian clothing. That I don't disagree with. Or the physical restraints. I don't disagree with that either. But we'll read it really quickly. Number 4, the presumption of innocence is a basic component of the fundamental right to a fair trial. Quotation, since the defendant pending and during his trial is still presumed innocent, he is entitled to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man, except as the necessary safety and decorum the court may otherwise require. He is therefore entitled to wear civilian clothing, rather than prison clothing as his trial. Okay. Number 5, defendant scheduled for trial on October 7. Defendant will be transported to Orange County Jail daily for her trial proceedings. Defense counsel will be providing the defendant with professional attire for the court appearance. In addition, the defense will need to obtain the defendant's measurements. Therefore, defendant requests his court to enter an order placing the Orange County Jail on notice that 1, defense is permitted to bring defendant's measurements, and defendant is permitted to dress out in civilian clothing for trial proceedings for October 7 to October 25. B, the right to appear without physical restraints. 6, allowing a defendant to appear before the jury in restraint devices is an inherently prejudicial practice that undermines presumption of innocence and the right to a fair trial. Generally, the defendant in a criminal trial has the right to appear before the jury free from physical restraints such as shackles or handcuffs. Number 7, September 19. Defendant appeared in court bearing handcuffs and shackles. The defendant's hand restraints made it difficult for her to communicate with counsel in written note-taking form. In addition, it is reasonable to assume that the next court hearings will be covered by local and national media. If defendants put on display to prospective jurors in jail garb, they will naturally be led to doubt in her presumption of innocence. I mean, you think that's the only reason? That's the only reason? Her being in jail garbs? Therefore, defendant is requesting that hand restraints be removed at all court proceedings from here on out, and both shackles and handcuffs be removed from during trial proceedings. C, the right to control appearance in the courtroom and before the jury. Okay, so this is for hair and makeup. 8, the courts have recognized that defendant's appearance can slightly impact the jury's perception and consequently the fairness of the trial. Estelle v. Williams. U.S. Supreme Court noted that compelling a defendant to stand trial in prison or jail clothing could impair the presumption of innocence, which is fundamental to the adversary system. Yeah, but is there going to be anything about makeup, though, and hair? Number 9, allowing the defendant to present herself in a manner that does not unduly prejudice the jury is essential to ensuring her right to a fair trial and upholding the presumption of innocence. And while the court in Estelle specifically addressed prison attire, the underlying principle applies broadly to any aspect of the defendant's appearance that could influence the jury's perception. Defendant has a right to appear before this court and prospective jurors in the same manner. I mean, just as long as she doesn't show up in the Lori Vallow clown makeup, because I feel like makeup, if you haven't applied makeup in a while, it could be hard to kind of do it again because you might overdo it or might not know how to apply it properly. But I think they want her to have a professional makeup and hairstylist every day of the court day. Like, I don't think she needs that. Defendant has a right to appear before this court and prospective jurors in the same manner as she would outside of the confinement. Cosmetics and hairstyling is standard practice and in presenting a professional appearance if the individual so chooses. Wasn't there a trial recently where, was it the Wade Wilson one? It was something about facial tattoos or something. Someone had facial tattoos and I think the judge allowed it to be covered. Something like that. By extension, incarcerated males are permitted a fresh shave and a haircut. Accordingly, the defendant requests that she be permitted access to cosmetics and hairstyling throughout her hair proceedings, including voir dire. Oh my lord, how much is that going to cost? Jesus. Okay. All right. Well, I think the state said they didn't really have a stance in it. The judge was like, "Oh, I don't know. I'll go to my chambers today and make a decision." So I'll keep refreshing to see if the judge has made his decision yet. Like he's usually pretty quick with doing all the uploads and all that stuff and making his decision. All right, well, what's the next one? What do we have next? Oh, hello, Mr. Bowles. We're gonna get to Mr. Bowles next, y'all. Get into Mr. Bowles next because you know who's here? Fucking Kari Morrissey. She's back. You gotta listen to the Kari Morrissey arguments. And, you know, I don't think we've heard from Kari Morrissey since the Baldwin trial. We read her motions and her response to all the criticisms, but we haven't heard from her yet. Wonder if she's going to go after Erlinda Johnson again. All right, so next one. State's motion to strike defendant's motion to suppress statement at Orange County. Oh, did I read this already? No, I don't think so. Orange County Sheriff's Office and state's response to defendant's motion to suppress the statements at Orange County Sheriff's Office. The defendant's motion is legally insufficient. Defendant recites allegations of facts, but not why any particular facts or facts is an issue. Quotations. The reason for suppression is required by Florida Rule Criminal Procedure is a boilerplate assertion that it violated the United States Constitution, the Florida Constitution. There is no different than stating a, quotations, search was performed, quotations, illegally, and quotation, improperly and unlawfully, quotation. Motion to suppress the study 11 authority cases were legally sufficient. The defendant has not cited even a single case that authorizes the court to grant her relief she is requesting. The state is left in the dark about what specific issues. I don't know. Sometimes I feel like Mr. Owens forgets to provide case law or something. I don't know. I remember that time when the judge and him were going back and forth, and the judge is like, okay, well, you know, can you like cite a case law? And Owens is like, yeah, I'm not prepared to do that right now. And it's like, come on, you gotta know that's gonna come up. But oh well. He's got a lot in his hands. You know, he's trying. He's doing his best. The state is left in the dark about what specific issues the defendant is claiming and what legal authority there might be for the court to grant the relief she requests. The court should strike the motion as legally insufficient. Number 2. Oh my gosh. Oh, the glamour shots. You guys remember the glamour shots? This is back when I was in high school. They had these glamour shots where you would get all dressed up. You know, usually you would wear a spaghetti strap top, your big old hoop earrings, your tight ass jeans. And then they're like these glamour shots where there's like bubbles in the background and stars and I don't know, all kinds of shit in the background. And then people would treat them like they're trading cards and just give them out. They were so expensive. So expensive. Number 3, in paragraph 5 or 6. Oh, better yet. You know what's the best shots? Those awkward family photo ones. Oh my gosh. I actually want to do that for a Christmas card this year. Just like super awkward poses and just like weird shit. I gotta get my brother and my sister to get in on this. Hi, Yifro. How are you doing today? Hello. Number 3, in paragraphs 5 and 6 of her motions, she alleges that she was detained for 14 hours. And during this time, she provided a statement to law enforcement. She does not challenge the admissibility of the statement. 54 hours of detention does not make a statement involuntary. Number 4, paragraphs 7 and 8 of the defendant's motion allege that law enforcement asked the defendant to turn over her phone and that she provided the means to unlock it to law enforcement. Bell v. State is informative on this issue if it is the defendant's position that this somehow rendered her statements to the following day involuntary. Number 5, Bell makes it clear that the police having seized evidence from a suspect and the suspect knowing they have seized evidence from her only goes towards the analysis as whether a future interrogation is, quotations, custodial, not whether the future statement is, quotations, involuntary. Because Miranda warnings were provided at the beginning of the interview the following day, this was not a relevant factor for the court to consider. Number 6, Bell is also informative on the distinction between Miranda violation and an involuntary statement, which will be discussed below. Number 7, paragraphs 9 through 11. I felt like when Mr. J was reading Mr. Owens' motions, I felt like he was just doing a lot of head shaking. Number 7, paragraphs 9 through 11 of the defendant's motion implied that law enforcement was being deceptive in their manner of summoning her for an interview. She did not know that was going to occur. Listen, when Sarah Boone showed up to that at the law enforcement's at the sheriff's office, Orange County Sheriff's Office, she had a list of questions that she wanted to ask them. It seems like she also wanted to engage with them as well. Because, you know, she had that entire list thing that she wanted to go through with them. I don't know if she ever did, though. Did she ever go through that list with them? Or did they kind of just interrogate her and then she ended up getting arrested? I don't remember. We're going to watch the interrogation video. Yeah, press the like button. Thanks. Yeah, if you guys enjoyed the stream, press the like button. Wasn't detained for 14 hours. She was excluded from the crime scene. She wants to look her best for the last 2 weeks. I don't want to ever see her again. Number 7, paragraphs 9 through 11 of the defendant's motion implied that law enforcement was being deceptive in the manner of summoning her for the interview. She did not know what was going to occur, so I'm going to read this again. Pursuant to... Hello? What's up with my camera? Did my camera just blip out for a second there? Pursuant to Bell, this one goes to one of the Ramirez factors in deciding whether Miranda warnings were required, not whether the statement is involuntary. All right, number 8. This is different from the deception that will lead to involuntary statement. The defendant received no promises of hope, leniency, or misrepresentations about the law. Both the United States Supreme Court and the Florida Supreme Court have held that deception alone does not negate voluntariness. That's a word, voluntariness. This includes misrepresenting a co-defendant's statement, false suggestions that law enforcement could arrange a satellite... Wait, what? False suggestions that law enforcement could arrange a satellite system to put a defendant at the scene, exaggerating the amount of DNA evidence against a suspect, informing a suspect that law enforcement was investigating a missing person case rather than a homicide, writing DNA evidence on the whiteboard in the interview room prior to any DNA analysis being performed. Oh, wow. That seems like a good one. And false representations of physical evidence that did not exist. Deception does not negate voluntariness. Oh, cool. Okay. Interesting. I mean, that would have me sweating. Imagine being accused of a crime. You come in, into the interrogation room and you see DNA evidence on the whiteboard. Might be sweating a little bit. Number 9. Luring the defendant to the sheriff's office under the guise of returning her phone to her is, if that is the fact what happened, does not make the statement involuntary. It only goes towards whether Miranda should have been read, and it was. Like I said, she looked like she wanted to go and talk to the law enforcement herself. That damn list of questions that she had. Number 10, paragraphs 12 and 13 only goes towards the first Ramirez factor as whether Miranda should have been read to the defendant. She was led upstairs to one of the interrogation rooms in the sheriff's office by Detective Lowen, where an interrogation ensued after Miranda was read to the defendant. 11, nor is there coercion. Although the defendant has not specifically made the claim or cited authority, Martin v. State allegations that law enforcement, 1, threatened the suspect with a death penalty, 2, deluded the suspect as to what he could expect for himself and from a jury if he confessed, number 3, deceived the suspect as to the amount of time he had to cooperate with law enforcement, 4, promised their favorable testimony and use of influence during his trial if he cooperated, 5, promised to arrange a visit for him with his girlfriend if he cooperated, and 6, exploited his religious beliefs by relying on a version of the Christian burial interrogation Relying on a version of the Christian burial interrogation technique did not render the statement involuntary, though it presented the very outer limit as to what tactics law enforcement may employ when performing custodial interrogation. Wait, what is this? Version of the Christian burial? I want to look more context about this. Although the defendant never states that part of the reason she believes her statement should be suppressed was a minimization of her Miranda warnings, nor cites any case law. Hey, who's that? Ben, the emotionist. Thank you so much for the tier 1 sub. Hey, 2 months in a row. Thank you. How are you? How's it going? Happy Friday. Who's riding a donkey? The awkward photos have to be so over the top that no one thinks it's real. Number 12, although the defendant never states that part of the reason she believes, I think I read this right, I'll read it again. She believes her statement should be suppressed was a minimization of her Miranda warnings, nor cites any case law. On the subject, the state infers that she believes this is an issue due to what she has underlined in paragraph 15 of her motion. I wonder maybe Mr. Owens just wanted to put these motions in and then he was going to do a amended motion with the case law after the fact. Or maybe argue case law when they're arguing in front of the judge, but not included in the motions. Just to have it out there, maybe. Number 13. There are several... Oh, I saw that Christmas card. Number 13, there are several cases addressing the issue of minimizing the importance of Miranda warnings. A bunch of cases here. 14, saying in quotations, this is something I have to do. Quotations is not minimizing according to Wright, which is analogous to Detective Culpso saying, so I'm going to read you your rights again because we have to talk about it, ... We just have to do it, end quotations. They were reading in a normal cadence like in Chafin. There's no delay in reading them. The defendant's not a juvenile. There's no claim that she is a below average intelligence. She's had her Miranda rights warning. She had been read her Miranda warnings just day before and acknowledged this. It is the defendant who says this is normal protocol. 15. The statements made by law enforcement did not render her waiver of Miranda rights involuntary or her statements involuntary under the totality of circumstances. Wait, why is that? Hold on a second. This sentence is like fucking me up. These statements by law enforcement did not render her waiver of her Miranda rights involuntary or her statement involuntary under the totality of circumstances analysis. Okay. 16. In the balance of paragraph 15 of her motion, the defendant outlines the Miranda warnings as they were given to her by Detective Colpsol. 17. Paragraph 17 through 21 outline what she believes that the sheriff's office Miranda card says and how it differs from what she was told by Detective Colpsol. 18. I always like this. When they start as, you know what? Hold on a second. I think my dog is messing with my camera. I think I'm cutting out. Give me a second. Let me make sure everything's dead. Sometimes he goes next to my desk and he yanks. Oh God, Shiro. He yanks the cords out. Or he loosens up the cords. All right. Love it when they start with interestingly, because I feel like they're going to be throwing some daggers here. Interestingly, the defendant believes that this creates some sort of illegal impediment to her admissibility of her 2-hour statement that day is not backed up by a single citation to any legal authority within or without the state of Florida's court system. 19. Instead, she makes a boilerplate assertion in paragraph 22 that her statement was involuntary and her waiver of her Miranda rights was involuntary. Number 20. Fortunately for the state of Florida, there is case law on this issue. 21. There's no specific way that Miranda warnings must be given, and with all due respect to the Orange County Sheriff's Office, they certainly do not have the authority to tell this court what sufficient Miranda warnings are. Number 22. While the 4 required warnings have been embedded in police practice, the specific words used vary, and the Supreme Court has not dictated the words in which the essential information must be conveyed. There's no talismanic incantation required to ensure that Miranda warnings are sufficiently conveyed. Talismanic incantation. Interesting phrase. Rather, the inquiry is simply whether the warnings reasonably convey to a suspect his rights as required by Miranda. The crucial task for determining whether police give a proper warning is what are the words in the context used, considering the age, background, intelligence of the individual being interrogated, impart a clear understanding warning of all their rights. Seems like it to me. Number 23, Detective Colpsol specifically instructed the defendant on each of her 4 Miranda rights. 1, right to remain silent. 2, that anything can be used against her. 3, she had a right to attorney before and during questioning. 4, a lawyer could be appointed if she could not afford one. The detective then asked the defendant if she understood these rights, and the defendant did say yes. 24, State v. Owens is directly on point. There, the defendant was reading the 4 Miranda rights, asked if he understood them, asked if anyone had threatened him or promised him anything. There's no mention of any question about whether the defendant wanted to talk to law enforcement after he was given Miranda warnings. This is apparently the Federal Bureau of Investigation's Miranda warnings, which are described as exemplary. Man, Mr. J is coming in with all this case law to back him up. 25. The Miranda decision never contemplated the waiver of counsel could be accomplished only by use of words, in quotations. I'm willing to answer questions without the service of a lawyer, end quotation. There's no magic in these words. Any clear and unambiguous conduct by a person who has been advised of his rights or indicates his willingness to answer questions without the lawyer is surely sufficient. 26. We're almost there, y'all. Almost there. She's going to demand smoky eye and false lashes. That might be a little too overkill for court. 26. Therefore, if the court does not strike the defendant's motion to suppress for being legally, I don't know, she might do the Jodi Arias route, you know? She might go in there looking all meekly and stuff, looking like a little school child librarian, wearing some glasses, you know, some like church-looking clothes. I don't know how she's going to do her hair, though. Okay, I don't know what's going on with my camera. I'm going to have to unplug it and then replug it all the way in. 26. Therefore, if the court does not strike the defendant's motion to suppress for being legally insufficient because it lacks case law to support it, it should deny it on its merits. If the court believes there was a Miranda violation, the defendant's statements are still available for use during cross-examination. Bell. Only if the court finds the statements to be involuntary will the state be prohibited from using them in cross-examination. They seem pretty fucking voluntary to me. What do you guys think? All right, refresh again. Let's see if the judge has made his ruling on the makeup. Not yet? What's this? Are these new? the amended witness list. Mr. Cacciatore. Where's Mr. Cacciatore? We haven't seen Mr. Cacciatore in these hearings. Has he been just dialing in? Notice of placement of the state witness on the state's Brady list. This is Mr. Cacciatore. Joseph O'Neill of the Orange County Sheriff's Office. Okay. This is the date and time for next week's hearing, October 2nd at 3 p.m. So 12 o'clock my time. They're going to address the... Oh, I thought the judge was going to make his decision for this weekend. Or is that something else? Am I confused? Maybe I'm confused. All right, so next week's motions. The defendant's motion to suppress defendant's statements at Orange County Sheriff's Office. They're going to address that. And defendant's motion for right to hair, cosmetics, civilian clothing without restraints for trial. Okay, for some reason I thought the judge said he was going to roll on that today in chambers. What kind of makeup would you need to look pitiful? I mean, I think the best way is just like no makeup. Go in there, fresh face. Maybe, I don't know if I would even wear mascara because, I mean, you gotta fake some crying, right? I won't even wear mascara because that might ruin, because you guys ever cry with mascara on sometimes if it's not completely waterproof? Oh my God, it just runs down your face. Horrible. I would just say, just go in there barefaced, you know? I don't know. Maybe give yourself a little bit of color, a little bit of life, maybe. I don't know. Maybe a little bit of a contour, bronzer. I don't know. Glasses. Yeah, no makeup, glasses, a little cardigan, a little skirt. I think she said she wanted to wear a long skirt. All right, y'all. So I'm going to keep refreshing this to see if there's anything else that's posted for today. A lot of action happening here. So, you know, so far, no continuance. They are still saying they're going to have their trial on October 7th. They did discuss jury stuff again. So the judge did mention that he's going to try to have 50 people in the morning, try to see if anyone knows about this case, have another 50 in the afternoon, and they're going to continue through this process until they have about 40 to 50 people to select from. And so we don't know if jury selection is going to be 1 day, 2 days, or 3 days. I think maybe 2 to 3 days. I don't know if they're going to get everyone in 1 day, but maybe people in Florida don't know about this case. Maybe they don't care about this case. Maybe they haven't heard anything about this case. Have I ever seen her cry? Nope. I have not. She didn't even try to eke out a tear when law enforcement showed up and George was dead. Didn't even try. Need openings on Sarah's birthday, 10/10. Oh yeah, her birthday is on 10/10, isn't it? Don't forget to wish her a happy birthday, y'all. Was this motion made when she was going to represent herself, or is this a new motion? When she was pro se, she fought a motion to get rid of like the bindings and all that stuff, and she wanted to be like free in the courtroom for trial and all that. In terms of makeup and hair, that's new today. That was followed by her defense team today. But I mean, Mr. Owens did mention it, I think, in the last hearing, that they want to do like hair and makeup. But I don't know. They're asking for a professional to do her hair and makeup every day. I'm like, every day? Maybe just have someone give her a haircut and that's it. Give her a haircut. I don't know. She wants to like wax anything. I think she looks fine. Her face looks fine. Give her, I wouldn't even give her a haircut. Her hair looks fine, honestly. I wouldn't cut it any shorter. Oh, gosh. She was discussing it pro se, now along with the shackles. Yeah, the shackles. Oh, hey, wait, Trial TV. I think we were just watching your feed earlier. Hello, how's it going? Do you think she can get off? I don't see how, man. I know they're trying to say, they're going to go for, hey, look at Sarah Boone. She's a battered spouse. George is a horrible person. They're going to say that. But like I said, this case is so unique in that he was in a suitcase begging to get out. She's laughing at him. She's making fun of him. I don't know. I don't know how you can garner, even though there might be some other instances where maybe like George beat on her, he was arrested, if they show bruisings and all that stuff. But I don't know. Like, you got to remember, like, he was in a suitcase. He was begging to get out. I think, if anything, the jury might have more sympathy for George, especially looking at that cell phone video. So it's going to be a tough one. But, you know, defense attorneys, they get really creative. They're really good at convincing people sometimes. We will see what happens. We will see what happens. You doubt that Judge Cranick will continue the trial? Yeah, me too. I don't know. I was like, you know, we're having a lot of issues here. got the delay, the hurricane. I thought the hurricane delays were going to be a lot longer. But it seems like the sun is shining now, but people are just having like floods and maybe losing power and stuff. All right, y'all. And then, I mean, for Sarah Boone, I'm just going to keep refreshing it. I really, really want to get to, dun dun, this right here. Miss Kari Morrissey. Kari. If you guys haven't seen the recap for the Alec Baldwin case and the reason why it ended and the case being dismissed against him, go watch that video, okay? That was wild. It was probably one of the most wild moments in court history for me. I know there was a lot of wild moments in the Depp v. Heard stuff, but I think this trumps it. I don't know. I think this trumps it. This was maybe second to best. I don't know. It was so crazy how everything just slowly unfolded. We were confused, and then we're like, wait a second, is there evidence that was withheld? What's going on here? And then everything just happened so quickly, and then all of a sudden we had Miss Morrissey, the special state prosecutor, testifying on the stand when she didn't have to. Okay, and then the judge was like, I'm dismissing this. I don't know. What a wild thing. So I don't think we've heard from Kari Morrissey since then. Kari Morrissey went up there to testify. She was cross-examined by Baldwin's attorney. Didn't do so well. You know, it was pretty rough for her. I think she thought she was going to go up there, wing it, and give her side of the story. And then she gave like a little mini interview outside of the courtroom. I haven't heard from her since then, unless you guys have. I haven't heard from her. But we did read her motions where, you know, she was going after her former co-prosecutor, Erlinda Johnson, you know, a little bit, just throwing some jabs there, saying that Erlinda Johnson wanted to, she only cared about self-preservation or something. And that Kari Morrissey, she wasn't about self-preservation. She wanted to get justice. She wanted to go Alec Baldwin. She wanted to go after Alec Baldwin. And, you know, she basically attacked all those criticisms head on. All the criticisms against her. I don't know. I feel like she's a hard-headed person, but she's back. I want to listen to her. I was stunned during the Baldwin trial. I was, dude. I think I stayed up until like 3 a.m. that day because I didn't watch it happen live, but I was getting updates about it as it was happening. And I was like, wait, it's dismissed? What happened? And then I decided to watch it before I went to bed, and I stayed up a little too late, and it was crazy. It was wild. I think Kari was going to break down, so she did better than that. Kari's, you know, she's got a strong personality. Strong personality. So you guys can see the title here. Hannah Gutierrez motions for immediate release. I think it's for immediate release, or they want a new trial. Honestly, what happened in the Baldwin stuff was really fucked. In terms of Hannah Reid, though, Hannah Reid's was different because her attorney knew about those ammunition that was under Troy Teskey's possession. I think it was during maybe one of the last days of the Hannah Reid trial, where he told Troy Teskey to, you know, give those ammos that he didn't want to use, give it to law enforcement because he didn't want to touch them. He didn't want to touch those evidence, right? So he knew about it, but he's saying that there's other things that the special prosecutor, Miss Morrissey, there were other things that she hid from the defense. And then what was there? Was there anything else? I'm sure there's a lot more. They'll discuss it here and we'll talk about it through. But man, Kari Morrissey's back, okay? But this is Mr. Jason Bowles. He is the attorney representing Miss Hannah Gutierrez Reid, who honestly, I mean, she might be out soon. No, she was serving 18 months. I think she's already like 6 months there. She's got another year to go. But if we do a whole new trial, yeah, Teskey was on the witness list. He was. Teskey was on the witness list. Hannah Reid's dad was on the witness list, and he didn't testify. Because honestly, if there was this whole thing about, you know, maybe it was Seth. Maybe Seth was the one that introduced these, you know, live rounds on the set. Well, I felt like we should have heard from Troy Teskey and we should have heard from Hannah's dad. They should have talked about, you know, what they thought happened, right? But they weren't called. So I was like, okay, so maybe it was like nothing big. Maybe they thought that, oh, hey, like there's no point in calling them because maybe it seemed like it was pointless to point their fingers at Seth. I don't know.
Judge, on July 31st, 2024 of this year, this court filed an opinion in the Baldwin case, and this followed a July 12th hearing in that case. In paragraphs 59 and 60, this court went through the findings of the state's egregious discovery violations, deliberate and intentional withholding of evidence, and in the court's inherent power.
I think it was something about another interrogation with Seth Kinney. It was something about the gun being damaged. It was someone's report. And then, I mean, he mentioned the Troy Teskey ammo as well, but it's like he already knew about it.
Stated that dismissal with prejudice was warranted to ensure the integrity of the judicial system. Now, part of the court's findings, and I'm going to relate them to this case, part of the court's findings also included that Ms. Morrissey, when she testified, called herself as a witness in that hearing on July 12th. Her testimony was inconsistent internally. Her testimony also conflicted.
Her testimony did clash with the lead detective. I forgot what her name was. I think it clashed with the lead detective and maybe with Marissa Popwa as well. I think Morrissey tried saying that she didn't know about the ammo being kept in a separate case file. She thought it was going to be under the same case number. She doesn't know how their systems work, which to me sounded like it was fair. But I think it was Marissa Popple or the lead detective that mentioned that, like, hey, we made this decision together. It was like us, Kari Morrissey was there, and we decided that, okay, we're going to, file this somewhere else. I don't know. Oh, there was a little bit of conflict there.
Conflicted with at least one other witness. Now, we have since supplied this court with affidavits from her former co-counsel, Erlinda Johnson, to highlight additional, we believe, false testimony that Ms. Morrissey gave to the court. Now, that's important because I think this court has to view through the prism of the prior findings of the.
Wait, what did your dad do? Sorry, I'm being so nosy. I never trust any of them. The video with Seth was withheld.
Affidavits, the comments Ms. Morrissey is making, and what I consider to be shade on the truth on her statements. Now, part of the court's findings at paragraph 10 in Baldwin's case included that the state had continuously made late disclosures and that the state had filed a certification, specifically Ms. Morrissey had certified that she had supplied all of the evidence required under the rules under 5-501. Now, that same thing occurred in this case. And Your Honor, post-trial, we have now learned that Ms. Morrissey never disclosed to us, and I'm going to get into these and why they're important, the Hague report from August 31st.
Oh, Hague report.
The Seth Kenney interview that I've highlighted in the motion. And the third one are these Teskey rounds. And I'm going to explain that in a little more detail as well. Now, the same thing the court found in paragraph 10 applies here. The state made that certification and it was untrue. Your Honor also found in paragraphs 27 and 28 that officer that CST Popple that testified in Ms. Gutierrez-Reed trial had.
Also, I don't know what Ms. Morrissey was thinking, but Ms. Morrissey, she's a private practice attorney. She is a criminal defense attorney, so she should know not to be doing this stuff. I mean, you should be doing it anyways because you're an attorney, right? But like, she's a criminal defense attorney, and then she also practiced. She does. I think she's like a civil rights attorney too, as well. I think.
Had given false testimony in Baldwin's trial. Specifically, there was a interchange between Ms. Morrissey and Ms. Popple, in which the idea came up in testimony before the jury that these rounds were not similar. The Teskey rounds were not similar to the rounds found in the rest set. The court then held a hearing on July 12th and actually ordered those rounds produced. And despite Ms. Morrissey's continued assertions to me, to the jury, and also part of her testimony that they were not similar, there were three very similar or identical rounds, Starline brass with silver primers. Now, as part of that aftermath, Corporal Hancock testified.
But see, when the judge got a hold of it, because the judge was like, you know what, I'm going to go check myself. She put on some gloves, she went down and she checked herself. And I think she realized, kind of seems similar.
Ms. Morrissey was part of the meeting to what I consider to be bury and hide the Teskey rounds that were turned in on March 6th in a separate case file under a separate number. Now, Ms. Morrissey stated that the first time she saw these rounds was July 12th. Then the court asked a question during that hearing to Corporal Hancock. Corporal, was Ms. Morrissey present in the meeting to put those rounds in a different case file under a different number? And she said, yes, she was. Well, and that's part of the court's findings in this court's order that Ms. Morrissey was part of the decision to hide those rounds, hide the supplemental report, and to not have that produced. Now, in Mr. Baldwin's case, the standard, as this court notes in paragraph 48, was evidence disclosed within a trial. Ours is obviously the standard post-trial. And so this court delineates that standard and how it's different for post-trial discovery of evidence. Now, that is that we have to show that there was a reasonable probability that the outcome would be different. And I'm going to get.
What? He would take cases retainers and not do anything on the case? He did it. What? Jesus.
Into that with each of our pieces of evidence. Judge, the fact of the matter is, we would have never discovered the Teskey supplemental report or what they had done with that if Baldwin's case had not occurred, if they had not done those interviews. We would have also not discovered the Hague August 31st report because those came out in Baldwin's interview.
I assumed that he knew about the Teskey rounds, right? And he was the one that told Baldwin's defense team, like, hey, like, by the way, there was these Troy Teskey rounds that made it to, law enforcement, and I'm sure Kari Morrissey knows about it. Have y'all heard about that yet? And then Baldwin's attorneys were like, no, what Troy Teskey rounds? I don't know, that's how I assumed how things happen.
In that subsequent case, those were never turned over, as was Seth Kenney. So they were all suppressed. Now, were they favorable? The court finds, as part of its order in the July 31st order, that there the defense had outlined a progressive trail of how the rounds got from Troy Teskey to the set of Rust. And that was in paragraph 30 of this court's order. The court went through how they went from Teskey to Seth Kenney. They went to the 1883 set and how they ended up on October 12th being given to Sarah Zachary. Now, the court also said that any additional information as to the source of live rounds or how they arrived on set would likely affect the jury's determination as to proximate cause and as to negligence of third parties.
Okay, let's say the live rounds were introduced by Sarah Zachary through Seth Kenney. It was still her job to check to make sure the ammos, anything that's being loaded in there were good, and it seems like she didn't check them thoroughly. She even mentioned saying that there was a box of rounds that she just shook them on, and they're like, oh yeah, they're all rattling, so we're good. It's like, no, you're supposed to go through the box and pick out one by one to make sure all of them rattle. I just don't see how it would change in any way. I don't see how the jury would have changed their mind in any way. Yeah, we did see her smiling here and there.
Under 14-251 UJI. Now, it is the same thing in Ms. Gutierrez-Reed's case, but the facts are different. The reason why the facts are different are that Ms. Morrissey, in effect, suppressed them, in our case, by telling Mr. Teskey she would retrieve these. She told him in his pretrial interview, and that's detailed in our motion, that she would retrieve these and the state was going to collect them. Now, that never happened. But by telling Mr. Teskey that, Mr. Teskey didn't want to do anything with those rounds. He didn't want to touch them, and he wanted to keep them secure and safe. Now, I was not able to see those rounds until the second to last day of trial was the first time I saw him. Mr. Teskey didn't want to bring them. He didn't want to be accused of tampering or obstruction. And I didn't want to, and Ms. Morrissey said, I didn't want the evidence. She, again, shades the truth. The fact of the matter is I didn't want to be in the chain of custody, nor did I want there to be any allegation that I had anything to do with something nefarious with regard to those rounds. So I directed Troy Teskey to turn those in to the sheriff, which he did, because we wanted law enforcement to have them, because I thought naively the state would do the right thing and would test them. Never in a million years did I think the state was going to hide those in a separate file under a separate case number, which then came out on the Baldwin trial. So that's what Mr. Teskey did. He turned those into the state. In the aftermath of that, we weren't told what happened. We weren't told there was a separate file. We weren't told any of that.
Well, I would assume that he would probably, even though the state should have done X, Y, and Z, it's like, oh, okay, well, should you have followed up to see if those rounds were ever tested?
Because Ms. Morrissey basically held those in place with Mr. Teskey, it's the same thing as the court found in the Baldwin case. We weren't able to test those. We weren't able to utilize those rounds. We weren't able to even touch them because the state was going to seize them. Now, had we been able to use them, it goes back to the court's paragraph 30 on outlining the trail of how the live rounds got on set and how they got in the hands of Mr. Kenney and got to Rust.
Hey, Alex.
The state's theory at trial against Ms. Gutierrez-Reed was based on a series of pictures that they put together that Ms. Gutierrez-Reed must have introduced the live rounds because here's the pictures. Well,
yeah, she was posing and there was like a tray of live rounds with a silver primer on them.
Well, in reality, now that we learn that Mr. Kenney could have introduced those on October 12th through Sarah Zachary, and the jury could have been shown and seen those rounds. I asked the state repeatedly to test them, and they would not. Even though they tested every other piece of evidence in this case, except the live rounds. They didn't test those for DNA and fingerprints, but they didn't test the Teskey rounds. They refused to. Your Honor, second, as to the Hague report, I think this is very critical. The Hague report and the one we're talking about, this is one that we never got during trial. Mr. Hague, the state's chief expert as to the firearms, made a report that says it seems unlikely, although it cannot be excluded, that these tool marks on the firearm are the result of the damage incurred during the FBI's impact testing. He goes on to say that they do not appear to be original manufacturing marks or use and abuse tool marks. Now then he follows with these tool marks are unlikely to have had any bearing on the operation of a revolver at the time of the incident based on the FBI's trigger pull data. However, The fact that he made the comments that they seem unlikely to have occurred during the FBI's
I thought, okay, the Hague report was when there's another man who observed and he took a look at the gun, and he was saying that, like, oh, it seems unlikely that the damage done was done by the FBI. I think that's what he wrote initially. But then afterwards, when he spoke to the FBI and learned what kind of testing the FBI did to the gun, he's like, oh, actually, you know what? Okay, I can see how the damage was done. Isn't that what happened?
impact testing and not consistent.
I know, exactly. Honestly, Hannah was still guilty. She didn't check. It was exactly. I'm like, I don't know if even if she wasn't the one that brought the live rounds to the set. I mean, it made it sound worse when we thought she brought the live rounds to the set, because it seemed like she did. But even if she didn't, at the end of the day, she's supposed to check them anyways. That's literally her job. That's literally her job. So I don't know how the jury would have changed her mind. Unless it was like, okay, she checked them, she made sure they were good, she gave the gun to the actor, and then she went to the bathroom really quick, and during that time the actor fucked with it, put something else in there, and then that's when it happened. But I mean, honestly, I think Hannah was supposed to stay with the gun the entire time, but she didn't. The gun was given to Baldwin at some point. I think Hannah wasn't even in the church during that scene. She was like outside in the cart with Sarah Zachary or something like that. Like she wasn't even. It just sounded like she never took her job super seriously, based on everything that the state showed us. Dave Hall, Dave Hall, Dave Hall.
With the original
Is he retired
markings,
yet?
we
Did he
could have
retire?
used that at the trial. And in fact, Your Honor, what's even more important is I asked Mr. Hague on the stand a very open-ended question. My question was, did you see any other evidence of modification or damage to that firearm other than what the FBI's testing did? He said, no, sir. Now, Ms. Morrissey tries to again spin that by saying that was in the context of the functionality of the firearm. I did not include the word functionality in that question. It was a very open-ended question. Mr. Hague said, no, sir. When in reality, both Ms. Morrissey and Mr. Hague knew at that time he had authored a report that showing that there was other damage to the trigger and to the sear. Now, later on, Ms. Morrissey points out in response, after Hannah's trial, Mr. Hague is able to learn more about the firearm, and then he's able to change his conclusion. But at the time of the trial, Mr. Hague got a report saying there were unexplained tool marks on the trigger and sear.
Oh, it was after the trial that he learned how the damage was done, and then he was like, "Oh, okay, I can see it was done by the FBI." Have fun, Christine. Oh, I'm getting hungry. I think we had a late lunch today.
And they weren't explained by the FBI's testing or the original manufacturer. Your Honor, we would have used that in the questioning and potentially raised an issue in the jury's mind regarding that jury instruction 14251, which is critical in this case. The jury sent out a question on that jury instruction. And that is, was this an uninterrupted chain of events? Or did something occur that interrupted the chain of events that would have been a proximate cause issue? If there was damage to the trigger sear, and we're able to cross-examine Mr. Hague on that, the jury doesn't have to believe his conclusion that this didn't affect the functionality. They don't have to believe that. And again, this goes back to Ms. Morrissey, who stated to this court repeatedly, certain items of evidence are not relevant.
He did, right? Because I remember the FBI guy went up there and he said that he destroyed the gun because they did this testing, and it's usually like a last resort testing because they know it will fuck up the gun. Was it just the one where he like hit it with the hammer?
It's her determination. She did things because they're not relevant, but that's not her call. That's not her call under the standard, under Brady and under exculpatory evidence, because the defense may have a different use for them. I guarantee I would have altered my strategy at trial, as the court said in the Allison case. And that case is where the court reversed a conviction of a defendant's arrest record that wasn't disclosed to him. Obviously, he knew about that arrest record, but the court said it could have altered strategy of the defense at trial had we known about it. They were going to use it. Well, the same thing is here. If I had known about the report, we would have highlighted that, and we would have made a strong argument under 14251. You can't be sure as jurors that this didn't affect it, because we have a report here showing from Mr. Hague there was damage that he can't explain. And he was a very important witness in this case. It's inexplicable that we didn't have this report. And Ms. Morrissey this trial ended March 6th. It was August 31st that Ms. Morrissey first indicated in an email that this report would be turned over, and it was her failure why it didn't get turned over. There wasn't a very good explanation. There is no good explanation for not turning that report over that we could have made use of. The other thing that's critical to understand is this was coming out during the Baldwin interviews, which was going on simultaneously as we were having our trial. So it's just inexplicable that Ms. Morrissey would have hidden this evidence for use in our trial. And Your Honor, finally, the Seth Kenney interview, that interview had several things, and this interview was suppressed.
Yeah, why was this? What happened with this interview? I wonder if it was because it seems like there were some personnel issues, maybe with Kari Morrissey. I think Kari Morrissey tried to say that the people that she was working with weren't living up to her standards, maybe, or vice versa. Maybe Kari Morrissey was too much and demanding, didn't get along with her. I wonder if because there's like personnel issues, that there's a reason why some things, sorry, I'm saying some things, but major things were missed. I don't know. It just seems like a huge fuck up. It's crazy. There was like all these discoveries. There was like a bunch of like discoveries that weren't given. And I think Orlinda Johnson found out about it. I was like, what did she say? It was like 50,000 pages, or it was a lot. That she was the one who ended up turning them over a couple weeks before the Baldwin trial started. But I just wonder if the Hague report was missed, if the Seth Kennedy interview was missed, because Kari Morrissey delegated to other people, they didn't do their jobs correctly, or there was like a miscommunication. Like, what happened here? Because it just sounds like a huge fuckery.
I would have crossed him on several of the statements. Now, Ms. Morrissey's comment is that we knew about these other items through other witnesses. That's kind of the general statement she's made in response. The facts of the matter, however, is that Ms. Morrissey vouched for Mr. Kennedy.
Thank you for the clarification. I figured. By the way, I'm not the Sarah Zachary. Her sentence will be over the time she gets into trial if that motion is granted. Yeah, I don't know. I was wondering if the judge was going to make her decision today, but maybe not.
Improperly in closing argument, saying he was, in essence, anybody that disagreed with what he said was lying, and basically that Mr. Kennedy was telling the truth. So it would have been very effective for us to be able at trial to have used Mr. Kennedy's own words in this interview that we did not get to cross him on statements he had made. So that is the import of that as to impeachment. These items are material, they are favorable. And Your Honor, I think the most significant thing that came out of the Baldwin hearing, and this court appropriately and was warranted, dismissed that case with prejudice because of the egregious and continuing pattern of discovering misconduct. And it didn't just start after Hannah Gutierrez-Reed's case. That's not, they didn't conduct themselves ethically and then all of a sudden unethically in that case. This pattern of discovery abuse occurred in Ms. Gutierrez-Reed's case in the same manner as it did in Mr. Baldwin's case. And because of that, we are asking the court to consider dismissal in this court's inherent power, and the court lays out in its order the court's inherent power to issue a whole host of sanctions, or in the alternative, a new trial, Your Honor, because it's the significance of the items that were suppressed, favorable and material to Ms. Gutierrez-Reed that could have been used. We also have a situation, Your Honor, where I'm going to ask the court to order in this court's inherent power, if this court orders a new trial, to remove Ms. Morrissey as special prosecutor. She has testified before this court, and I submit, and I don't do it lightly, her testimony was false in several material aspects. This court's findings in its order indicate that at the very least, she didn't exercise reasonable diligence to ascertain the nature.
Can't wait to hear what Morrissey's going to say about those.
Of those Teskey rounds, because she was at that March 6th meeting. But I would say at the worst, because Ms. Morrissey's been thorough in other aspects of this case, she did see those rounds. She did know that they were, there was 3 silver primer rounds before July 12th. And so, Your Honor, I'm asking that this court in its inherent power remove her from further prosecution of the Rust case. And we are asking for a dismissal on the same basis as this court dismissed Mr. Baldwin's case.
All right. Ms. Morrissey, you there?
All right, thank you. Response?
Initially, I want to just ask, Mr. Bowles indicated that there was an affidavit provided by Ms. Johnson. I don't have that. I haven't seen it attached to any of the pleadings, so I'm not sure what he's referring to. So if obviously he mentioned it, can I get some insight into when that was provided?
Wait, is there an affidavit?
Your Honor, I will try to locate this in the pleadings, but there was an affidavit filed with that's in the court record in the recent Baldwin response. But I think I've attached one in this case as well. I just would have to find it.
Well, is it in here? When did you file it?
Judge, I thought I filed it with our motion, our reply to dismiss, but I'm not seeing it right away.
I'm not seeing it either, Mr. Bowles.
The motions I printed out don't have the exhibits, Your Honor, so I'm not seeing it.
No.
Well, I just went through every motion that's on Odyssey that has the exhibits attached, and it's not there. So
All right, if you can't produce it, I'm going to strike that part of the argument regarding Ms. Johnson.
Yes, Your Honor, and I would just say that part of the court record in the Baldwin case is that there is one filed in the recent response. Mr. Nika's file.
But it's not in this case.
Yes, I can't find it readily, Your Honor.
Okay, so I'll strike that part. Go ahead, Ms. Morrissey.
Um, I will say though that this is an issue that Mr. Bowles raised in his initial motion for a new trial. I responded to it. I stand by my response. I summarized the conversation that I had with Ms. Johnson, and Ms. Johnson indicated that she wanted the case dismissed out of issues that she was concerned about for self-preservation.
Oh, self-preservation. There it goes again. We got to get this affidavit. Guys, do you guys know where this affidavit is at?
I disagreed with that. I don't think self-preservation is a reason that you dismiss a case. There's a legal analysis that has to be done in order for the court to consider disqualifying a prosecutor. Mr. Bowles hasn't cited to any of those cases, and he hasn't put that legal analysis in any of his motions. So I would ask the court certainly not to consider granting that without a motion that actually addresses the law and the facts as they relate to the law. This isn't something that you just randomly ask for. The legal analysis has to be conducted, and it hasn't been conducted here. So having said that, I responded to Mr. Bowles's concerns about the veracity of my testimony. Quite frankly, I'm not sure that it's relevant to his motion for a new trial, but because it's something that he's put in his motion and it's something that he has argued, there was no meeting about these Teskey rounds. I did not attend a meeting.
They made it seem like it was a meeting. They made it seem like, her lead detective and whoever the other person was got together and was like, okay, well, here are the Teskey rounds. All right, well, let's file them in a case number.
Not see the rounds until July 12th. I did not see the doc report until I believe it was July 12th or July 11th. I'd have to check my email. Whenever I got it, and I provided it to the defense attorneys. I had no idea that there were 3 rounds that had the same characteristics as the live rounds from the set of Rust until July 12th. Mr. Bowles can complain all day long that he thinks that's not true. I'm telling you it's true. And how that ended up happening.
It's in Alex's motion. Where is I have Baldwin's case stuff up, but there's no files on there. Where is it? I want to see it.
Is actually quite clear, because what happened in this case is that Mr. Teskey took a photograph of the rounds that he had in his possession and he sent it to Seth Kinney. We ended up with that photograph. I've included that photograph in my response to this to Mr. Bowles' motion for a new trial.
Oh, I found it. I got it. Okay, I got it. Let me I got it. Okay, let's read it. Okay, Erlinda Johnson. This was filed 7 days ago, about a week ago. Affidavit of Erlinda Johnson. I, Erlinda O. Johnson, being age of a majority, do hereby attest the following. I am a duly licensed attorney in the state of Mexico in good standing, authorized to practice for every court in the state of Mexico, United States Immigration Court, United States District Court for the District of New Mexico, United States District Court for the Western District of Texas, United States District Court for the District of Colorado, United States 10th Circuit Court of Appeals. I have been practicing law for over 28 years. My office is located in Albuquerque, New York. On April 16, 2024, I was appointed to work as a special prosecutor on State v. Baldwin as co-counsel for lead special prosecutor Kari Morrissey. Kari Morrissey did not give me an expert report reference as the third Hague report prior to the defense's pretrial interviews of the experts Mike and Luke Hague. Kari Morrissey did not tell me the third Hague report existed prior to the first Hague PTIs. Kari did not tell me about the third Hague report until May 21, 2024. Had I known of the third Hague report, I would have disclosed it to defense counsel. Approximately 2 or less weeks prior to trial, defense counsel emailed me only asking to review a production provided by the district attorney's office to the defense pursuant to the Inspection of Public Reports Act, IPRA, for discoverable materials to disclose to the defense, as the IPRA production has been heavily redacted by the issuing agency. 9. Kari Morrissey suggested to me that I ignore the discovery request from the defense counsel. I told Kari Morrissey I would not ignore defense counsel's emails. I had my own ethical obligations to ensure the proper discovery was disclosed. Kari, what are you doing over there, Kari? I then asked 2 private investigators to assist me in reviewing the nearly, oh yeah, here it is, 5,000 pages. I think I said 50,000 something earlier, 5,000 pages of the IPRA production for the purpose of unredacting everything to which the defense was entitled. I conducted a review of the redacted IPRA material and compared it to the unredacted version. I also compared the material to the investigators' unredacted. After conducting the review of the IPRA production, I uncovered additional items to disclose to the defense, which amounted to thousands of pages of documents. This was referenced back in one of the pretrial hearing stuff, where, you know, there was a recap of all the discovery violations. They were going through it, and then they reference this 5,000 pages of like report. Okay, Kari Morrissey instructed me to not talk to the defense counsel over the phone. The trial began on July 9, 2024. I resigned from the prosecution on July 12, 2024 during trial because I learned of undisclosed evidence during the trial and felt my ethical obligations called for me to withdraw. I did not resign from the case because I did not want a public hearing on the discovery issue. During the lunch hour on July 12, I advocated for Kari to dismiss the case against Baldwin. During the break in the morning and lunch hour on July 12th, after conducting the legal research and evaluating what I learned that day about what had transpired with the Teskey ammunition evidence that had not been disclosed to defense, I believed the right thing for the state to do was to dismiss the case on its own motion, but Kari Morrissey disagreed. Boom. What are all these? Okay, so these are... This is filed by Baldwin's people. Oh, gosh. Okay, this email's from April 10 from Sarah Clark. Who is Sarah Clark? Evidence inspection request. Is this from the defense team? Sending it to Marissa Popple and Kari Morrissey. Good morning, all. Confirming that all the evidence we know we will want pulled includes the below, some of which are in the position of the Haigs. Gun from the scene, prop truck or PDQ. Number 2, when highlighted, all ammunition, including any located in the scene, prop truck, PDQ, or used for comparison, blanks, dummies, live, dentex, to include associated boxer bags and any of the ammunition was located. So that's in highlight. This is from Marissa Popple. Man, all these people. You think Marissa Popple's going to get in trouble? Well, I don't know about Marissa Popple. Marissa Popple is the crime scene tech, right? What about the lead investigator? Okay, so these are just emails. Let me get a protein shake really quick. I'm hungry, and then we'll get back to Mr. Bowles and Ms. Morrissey. Ms. Morrissey. Little corgi. Erlinda went to the defense to give the affidavit. Oh boy. Does Kari still have a job? I mean, she does. She's here arguing against the Hannah Reid motion. Okay, Kari.
It does not show any ammunition that looks remotely similar. Included that photograph in my response to Mr. Bowles' motion for a new trial. It does not show any ammunition that looks remotely similar to the live rounds that were found on the set of Rust. He went further than that. Mr. Teskey said, I looked at these rounds, I couldn't find any with silver primers. Okay, so at this point in time, the state, this is long before I ever came on the case, but the state understands at that point that the ammunition that he is in possession of does not look remotely similar to the live rounds on the set of Rust, that doesn't make them material. It's okay for us to say we're not going to collect those because he sent pictures and they're not material.
Mm-hmm.
Then we go ahead and we do his pretrial interview. And I decide maybe I should go ahead and collect those. So I make that statement to him during the pretrial interview. Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email.
I thought she said she was going to do it. Hold on one second.
His pretrial interview. And I decide maybe I should go ahead and collect those.
Okay.
So I make that statement to him during the pretrial interview.
Okay.
Mr. Bowles can argue all he wants that he was assuming that we were going to take him. He had no idea that we weren't going to collect him. I had an email exchange with him in January that's attached to my response.
Why did she decide not to collect them?
Where I explained to Mr. Bowles, I am not collecting that ammunition. If you want it collected and you want it tested, go ahead and do it and ask for a continuance of the trial. That is a conversation that took place over email and it is attached to my response. So Mr. Bowles understood we were not going to collect it. And it was during that email exchange that Mr. Bowles then provided more photos of the Teskey ammunition. And those photos matched exactly the photos that were provided to Mr. Kinney by Mr. Teskey. And they showed rounds that were completely dissimilar to the live rounds on the set of Rust. This is information that is coming from Mr. Teskey and it's filtering through Mr. Bowles. So Mr. Bowles doesn't get to come to the court now and say, hey, they should have collected these. The information that he gave us caused us to reasonably believe that they were completely immaterial. We had no idea that any of those rounds matched the live rounds from the set of Rust. Mr. Bowles provided us a photograph in January.
She's like laughing. Can we see these pictures, please?
A month before the trial, for heaven's sakes, that showed that they were completely dissimilar. So then let's jump to the trial.
Okay.
This is where Mr. Bowles' argument completely fails. He wants to rely on the court's dismissal of the Baldwin case, but he can't rely on that because what happened was these rounds were in the possession of his witness. He told his witness to bring them to court. He got to look at them. He told his witness, I'm not going to call you as a witness and I'm not going to take these rounds. We're not going to touch any of this. I understand why he did it. Because again, as I have said, sure, in a world of infinite possibilities, can you argue that these rounds somehow came on through Seth Kinney? I guess, but you can certainly you have a much stronger argument that this is how they came on through Ms. Gutierrez. Her father had these rounds that were exactly like the rounds that she brought on. So Mr. Bowles knew about this during trial. So when we're doing the legal analysis for whether or not Ms. Gutierrez gets a new trial, she does not get a new trial based on this ammunition that was in the possession of her father's good friend and that she and her lawyer had during trial. The state did not have. She and her lawyer had them during trial and chose not to use them. That is exactly what happened. So the legal analysis.
The judge is probably saying like this.
The 6 factors that this court has to look at when deciding to grant a new trial. The second one is that the newly discovered evidence has to be discovered after trial. That's not the case here. This evidence was discovered by Mr. Bowles during her trial when the state had no idea what those rounds were comprised of. He made the judgment call, hopefully after consulting with his client, not to call Mr. Teskey and not to use the rounds. They don't get to now come and say, we made a strategic error, so give us a new trial.
Okay, so, but I want to know, what is she going to say about the Hague report and, the Seth Kinney interview?
That's not how this works. So the issue of the Teskey rounds with regard to Ms. Gutierrez's motion for a new trial, it is absolutely, it's not permitted under the law. It was not discovered after trial. Here's the other thing that the court needs to take into consideration. A motion for a new trial can be filed for almost any reason within 10 days of the conviction. Mr. Bowles is limited to a motion for a new trial based on newly discovered evidence beyond the 10 days. So Mr. Bowles, having seen those rounds for himself on the second to last day of trial, having infinitely more information about those rounds than I had, easily could have filed a motion for a new trial within the 10 days, but he chose not to do that. So he has given up, he has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial,
Here's a judge.
and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that he is required to meet.
Where's Hannah? I think Hannah Reid is somewhere in this call. Do we get to see her? There was like a screen grab of her in the thumbnail, but I didn't. Is she here?
That is required for a new trial. Never one time. Our trial has waived his right to use that in a motion for a new trial. Furthermore, I want to point out to the court, Mr. Bowles filed a lengthy motion for a new trial, and never once did he articulate or argue the legal standard that is required for a new trial. Never one time. And I'm glad that Ms. Gutierrez is listening to this, because the legal standard that he is required to meet was never mentioned one time during his motion. The state mentioned it in the state's response, because these are the 6 factors that the defendant has to meet in order to get a new trial. So let's move on to the Kinney interview. Mr. Bowles
Kinney interview
outlined, I think, approximately 20 statements in that interview that he had specific concerns about. And he's absolutely right. I want you to know this was suppressed. The moment that I found out that this audio recording existed at the district attorney's office, I immediately provided this to Mr. Bowles.
Did you?
I couldn't believe that there was an audio recorded interview of this witness that had been sitting at the district attorney's office that had never been uploaded to the discovery server. The previous prosecutors were unaware of it. I was unaware of it. My team was unaware of it. It was absolutely a failure. There's no question about it. I immediately provided it to Mr. Bowles.
When?
But that's not the end of the analysis. The analysis is Mr. Bowles has to meet those 6 factors in order to get a new trial. So what Mr. Bowles did was he filed a motion and he outlined 20 statements, the vast majority of which were statements previously made by Mr. Kinney that were already in the possession of Mr. Bowles and Ms. Gutierrez. So then when we get to Mr. Bowles's reply, what we see in the reply is that the 20 statements have now basically been narrowed down to 5, because someone had to come and point out that Mr. Kinney had already talked about the fact that there were 325 rounds that were taken to Texas. He had already made all of those statements about Sarah Zachary being the boss. He'd already made all of these things. So Mr. Bowles filed this motion, having seemingly not reviewed any of the discovery that was in his possession with regard to Mr. Kinney's statements, so that he could file a motion that actually had the material issues related to the Kinney interview. So now we're down to the 5 issues that Mr. Bowles ends up relying on, because the other 15 turned out to be things that really were already in his possession, were already within his knowledge. So when we go through and we look at these, I'm sorry, there's I think he narrowed it down to 8.
Okay, 8.
So where he is right now is he's asking the court to grant a new trial, because the interview with Mr. Kinney talked about that there was a standard that Ms. Zachary was the boss and she's managing things, which allows the armorer to focus on guns. This came out during trial. Not only did it come out during trial, it was fully articulated in the text messages between Mr. Kinney, Ms. Zachary, and Ms. Gutierrez. Hannah has more experience on Westerns than Mr. Kinney did until 1883. Well, I would hope so, because Mr. Kinney is not an armorer. So the comparison between Ms. Gutierrez's experience and Mr. Kinney's experience has absolutely nothing to do, is completely immaterial with regard to this case. And importantly, the factors that this court is required to consider do not create a situation where Mr. Bowles gets a new trial because there's something out there that could be potentially impeaching. The law actually doesn't give him that with regard to a new trial. His third issue, prop masters who handle guns won't call out armorers to test bullets. I don't understand. I mean, I don't understand how that could even be remotely material. We had plenty of evidence from people who were on the set, who work on movie sets. Mr. Kinney does not, by the way. He doesn't work on movie sets. And we had an expert come in and say that armorers are supposed to test the bullets. So how is this material? The sheriffs confused the replica guns with the real guns. What does that have to do with the...
I get the eye twitch when I'm really fucking tired.
...elements of the offenses that Ms. Gutierrez was charged with? It has absolutely nothing to do with those. Mr. Kinney heard nothing but good things about Hannah on set, and all of the concerns about safety that came out later he hadn't heard about. Judge, that's all in the text messages that Mr. Bowles had. He had all of that. Mr. Kinney actually, there's an exchange between Mr. Kinney and Ms. Gutierrez where she talks about the director saying what a good job she was doing, and Mr. Kinney responds. All of that is in the text messages. This was always in Mr. Bowles's possession. Mr. Bowles didn't review it. He didn't use it during the trial. That was his decision. Sabotage could be anyone on set. Mr. Kinney doesn't work on movie sets, and he was never on the set of Rust. Okay, so this is his speculative opinion. It was also something that Mr. Bowles had the opportunity to fully explore at trial, and did in fact fully explore at trial. Because Ms. Gutierrez left the ammunition unattended, anyone could have messed with it. Yes, we went through all of that. Because these firearms were left unattended, yes, anyone could have messed with them. We knew all of that. All of that came out during trial. The idea that if the camera crew had gotten their hotels, would they have still felt unsafe? This is number 7 in Mr. Bowles's reply. This has absolutely no material value with regard to the case against Ms. Gutierrez in any way, shape, or form. That the assistant director and Alec Baldwin didn't give Hannah every ounce of support and she got pushed around. Well, this was Mr. Kinney's opinion, but you also have to keep in mind, Mr. Kinney was never on the set of Rust. Mr. Kinney never met Mr. Halls, the assistant director.
Who's she talking to? She's making an argument to the judge right now.
He also never met Alec Baldwin. So this is a statement that he made that has absolutely no foundation, and also is completely immaterial to the case against Ms. Gutierrez. Now, we get into the issue of the third Hague report. And look, I understand that to a certain degree, the job of a defense attorney is to make things seem perhaps a little worse than they are because it helps their arguments. Nothing was intentionally buried. This case had a terabyte of discovery. There was new discovery coming in constantly. This was a report that I believed I had forwarded on to our staff to have it uploaded to the server. When I realized during the Baldwin preparation for trial that did not occur, I immediately I took full responsibility for it. Mr. Bowles points to the email where I took full responsibility for it as though I've done something wrong by taking responsibility for it. I believe that it had been forwarded on. I went back, I looked, it had not been. We did the best that we could to resolve it at that point in time. And listen.
But here's the issue though. It's just like, it's not just one thing. It was like 2 things, and then it turned to 3 things, and then other things, and then now you got Erlinda Johnson's affidavit here. Like, it's just piling on up. Like, we understand people make mistakes. Shit happens. But it was just like, there's just too many that are happening, you know? At some point, it just has to look like it's just reckless.
The problem with Mr. Bowles' argument with regard to the Hague report is twofold. First of all, the Hague report clearly says the microscopic marks on the tip of the sear did not affect the functionality of the gun. Furthermore, Mr. Hague has since learned exactly how the destructive testing of the gun was being done and has now come to the opinion that these microscopic marks were made by the testing at the FBI.
Mm-hmm.
So Mr. Bowles wants to say, Judge, it doesn't matter. The fact that the guy has changed his opinion after he got new evidence, that stuff shouldn't matter. Well, it most certainly does matter, because when you look at the 6 factors that this court has to consider when granting a new trial, is the probability that the result would be different if the new trial was granted. So if you have an expert who said, initially, I'm not exactly sure where these microscopic marks came from, but I don't think that they came from the FBI. Then he goes and he talks to the guy at the FBI, gets more information about how that testing was done, and the expert then says, okay, now that I've got this new information, I've changed my opinion. I think that they did come from the FBI. Well, that goes directly to the first prong of the 6 prongs, which is whether or not a new trial would result in an acquittal if the court were to grant the motion. It's not going to, because Mr. Haig got more information about the testing, modified his opinion. And the other thing is that Mr. Bowles hired, although I don't think he paid him, but he had his own firearms expert. Not only did he have his own
Oh no, not Mr. Bowles not paying his own expert.
firearms expert, he used an investigator in this case who purports to have a fair amount of expertise in firearms. So
and I think Kari was trying to I think she was trying to throw some jabs at that expert. She was like, oh, this is the same expert that pointed the gun towards the judge during the trial. I think she concluded that in her response.
You've got basically 2 people who have expertise in firearms working for the defense, and you have the photos of the sear and the microscopic markings on the sear that were provided to the defense for their review. Not only did they have the photos, but the gun was sitting over in evidence. They can go, they can look at the gun, they can take the gun, they can test the gun, they can do any of those things, and they opted not to do any of them. Now, presumably, either the defense expert, Mr. Kuski, or the defense investigator was tasked with going through all of the photographs that Mr. Haig took. What Mr. Bowles has actually said in his reply is, oh my gosh, Judge, there were so many photographs. We can't be responsible for having to review all of those. They certainly can be. They needed to review each and every photograph. I know how long that takes because I did it myself. So the basis of the Haig opinion was always in the possession of the defense. And they seem to just basically...
Hello. Thank you so much for the tier 2 75 months on Twitch. What's up, boy? How are you doing today? Mr. Bose is a cheapskate. You love my shirt? Oh, thanks. It's from Uniglow.
Ignore the fact that they had the photos, that they had their own expert, and they basically had their own expert come in and say, we agree with Mr. Haig, the gun worked fine. That was the reason that they called that expert, was just simply to say, we agree, the gun worked fine. They had everything that they needed. But listen, I'm not trying to take away from the fact that this was a report that should have been provided and wasn't provided.
Okay.
I have taken full responsibility for it. I will continue to take full responsibility for it. So I want the court to know I'm not trying to get around that. But one of the factors that this court has to consider is, would the newly discovered evidence have been discovered before trial by the exercise of due diligence? They had a photograph of it. They had a photograph of the markings on the sear, and not only was it a photograph, right next to it is a photograph of a sear without those markings. It was in the possession of the defense the entire time. So this easily could have been discovered by due diligence. That due diligence meaning simply go through the discovery that you have. Go through the discovery that you have. And you know, New Mexico is unlike so many other states, in fact, perhaps all states, because defense attorneys actually get to interview the state's witnesses.
Mm-hmm.
So that is the opportunity for the defense to exercise their due diligence to discover things. That's the whole point to the pretrial interviews.
Mm-hmm.
So in this case, what happened was we had a pretrial interview scheduled of Mr. Haig. Mr. Bowles did not attend because Mr. Bowles did not attend, I think, 95% of the pretrial interviews. So he opted not to attend. He left it to his investigator. His investigator conducted a 25-minute pretrial interview, and not a single question was asked by the defense investigator about any of the photographs.
I'm surprised she didn't reiterate. Hey, Hannah, I'm glad that you're listening to this. Your attorney didn't attend 95% of these pretrial interviews. Just letting you know. Made the private investigator do it.
That the Haigs took. They asked about the damage to the gun. Mr. Haig indicated there was damage to the gun. He further indicated that the sear was damaged. That came out in the pretrial interview. So when you look at the 6 factors that the court has to consider when granting a new trial, the defense doesn't get there. They simply do not get there. I further have some concerns for the record. So one of the issues that Mr. Bowles has made an issue in these motions, which is a little confusing to me, is the issue with regard to the standard of state v. Ware. So what he's arguing is that the ammunition that's in Teskey's possession, under Ware, the state had the obligation to go and collect, and by not collecting it, that resulted in a due process violation to his client. Here's the problem with that argument. I sat and went through every single New Mexico case related to Ware. I can give you the list.
Okay.
And for the record, because we have so many potential appellate issues, I'm going to tell you, Judge, not only did I look at State v. Ware, I looked at State v. Crone, which was provided by Mr. Bowles. I looked at State v. Kinney, State v. Torres, State v. Martinez, State v. Camden, State v. Rodriguez, State v. Bailon Escobedo, State v. Baca, State v. Garcia, State v. Kant, State v. Taylor, State v. Perkins. Those are the New Mexico cases that discuss the Ware standard. Every single one of these cases says that the obligation of the state has to do with collecting evidence from the crime scene, and they make it very, very specific. And Ware indicates this is very limited. The state is not required to scour the planet Earth for potentially exculpatory evidence. It is evidence that is from the crime scene. This is not evidence that was from the crime scene. This is evidence that was in the possession of a defense witness. Mr. Bowles knew in January that we weren't going to collect it.
Getting a recap.
He knew that it had never been collected. He certainly did know that because he was in contact with Mr. Teskey. Mr. Bowles could have had that ammunition tested. I mean, the chain of custody was shot. There was never going to be any chain of custody with this anyway. This isn't something that was located at a crime scene and was taken into evidence. This is something that was sitting in a defense witness's garage. So Mr. Bowles could have had this tested. He opted not to have it tested. He could have had it tested. He could have had those test results compared with the test results of the FBI. And the best case scenario for the defendant is that would indicate that the same powder that was used in the ammunition that was in Teskey's possession is the same powder from the powder, or consistent rather, with the powder from the ammunition from the set of Rust. And that exact same powder is used in millions and millions of rounds of ammunition everywhere. One of my concerns since this issue arose has been the fact that Mr. Teskey 2 times sent photos of the ammunition in his possession, twice, and never sent a photograph of a round with a silver primer. In addition to that,
That's what I want to know about. What is going on with these fucking rounds?
Indicated, I have looked at these rounds and there are none with silver primers. And then 2.5 years later, he shows up with ammunition that looks just like the ammunition from the set of Rust. And again, you can buy this ammunition at any gun store. This isn't special. You can get it anywhere. You can get ammunition with these exact same characteristics at any gun store. So out of, to be thorough and complete, the Ware analysis doesn't match in this case. It absolutely is really irrelevant to this case because the defense had more access to this ammunition than the state did prior to Ms. Gutierrez's trial. Now, with regard to the Baldwin case, that's a completely separate issue because that is information that was in the state's possession prior to his trial. So there are real issues with regard to that disclosure. That's completely different. This case, Mr. Bowles had it in his hand. He had it in his hand during trial. And Mr. Teskey, I'm not making...
I wish we could see everyone's facial expression. I want to see Mr. Bowles' expression. I want to see Hannah Reed's expression. I want to see the judge's expression. I wish we could see everyone's reaction to everything that's being said.
Things up. Mr. Teskey told law enforcement on video,
can't stop,
I
won't
offered
stop.
this to Mr. Bowles and he said he didn't want it. That's what Teskey says on the video. So, you know, Mr. Bowles acts like I'm pulling this out of thin air. I'm not. That's what Teskey said. He said Bowles didn't want it. And again, Judge, I understand why he didn't.
All right, so we loop it now. I think that's the end of the argument, okay? I think that's it. That's it, right? Is there more?
So I
Oh, there's
also
more.
want to articulate, because I think that this is an issue that Mr. Bowles is raising and is arguing specifically with regard to the reply that he filed. And let me be specific in his reply, if you'll give me just one moment.
Take your time,
I'm just
ma'am.
reviewing my notes here real quick. So with regard to Mr. Bowles's reply, he says, both parties, the defense and the state, knew that Teskey had ammunition from the same batch that Reed and Kenny took to Texas. I disagree with this statement insofar as it oversimplifies what happened. So both parties knew that Thel Reed possessed a variety of .45 caliber ammunition with a whole lot of different characteristics. That was that was proven by the photographs.
My dog likes to go up to the mirror and sniff himself in the mirror. I wonder why. What are you doing? You smelling yourself? What are you doing? You funny guy.
It was proven by the ammunition that was taken from PDQ into the sheriff's department. So, but what there's no proof of, absolutely no proof at all, is that each type of ammunition that was in Mr. Reed's possession went to Texas and then went to New Mexico. So if Mr. Reed has 20 different types of .45 caliber ammunition, and it strikes me that he had about 20 different types of .45 caliber ammunition, there's absolutely no evidence or testimony that the ammunition that is silver primer starline brass with that particular projectile shape ever went to Texas, let alone ever came to New Mexico. So when we say it came from the same batch, I guess my concern is, what do we mean by batch? If there is evidence, actual evidence, that these specific rounds went from Arizona to Texas to New Mexico, I've never heard it.
Just sniffing a dog that looks like me.
Mr. Bowles actually went so far in his reply to say that the Teskey evidence was deliberately hidden from him. The Teskey evidence wasn't deliberately hidden from Mr. Bowles. It was provided to him by his own witness. He could have had it tested at any point in time. I would respectfully ask the court to deny Mr. Bowles' motion, and if Mr. Bowles wants to file a motion...
Respectfully, after grilling him.
Over and over again. Disqualify me, he can file that motion. That is a separate motion. There is case law on that motion. I would ask the court to deny this motion. Thank you.
Damn, she says, do it. I don't give a fuck. Do it, Bowles. Mr. Bowles' response?
Thank you, Ms. Morrissey. Reply, Mr. Bowles.
Yes, Your Honor, thank you.
Judge.
Your Honor, I want to start off by telling the court several initial points. The Teskey evidence that was deliberately withheld was the Teskey supplemental report. We still have Brady rights on appeal. That was not given to us, the March 6th report. So Ms. Morrissey misconstrued that. She also misconstrued the idea that I didn't want the evidence. What I told Mr. Teskey was that I didn't want to be in the chain of custody of those rounds. And it was actually a good idea that I did not, because Ms. Morrissey is now accusing Mr. Teskey, in essence, of planning silver primer rounds in that group of rounds. She just made that argument. Now, Mr. Teskey originally, way back when this case
started. Why weren't they in the picture, though? If, silver primer is definitely a contention, why weren't they in the pictures?
Did a cursory search through the rounds and did not locate any silver primer rounds. He thereafter didn't touch them. And that's where the text came from very early on. He didn't touch them.
Okay.
Ms. Morrissey was saying she's going to come get them. That's what she said at the interview.
Okay.
So by the time we have the email exchange, which by the way, Your Honor, she didn't email me. I emailed Ms. Morrissey trying to figure out where this was at. And then she responded, I'm not going to get these rounds. It was too late. This court, it made clear, and I don't remember the exact date, but that we weren't going to continue the trial. There was not sufficient time at that point to test them. And we could not test them, Your Honor, because the FBI had the powder for the live rounds on set. We don't have an ability to match those unless they're tested at the FBI. So the state did suppress those. And we're not asking on the Ware standard for them to go to the ends of the earth, as Ms. Morrissey said. They knew the individual who had them. They knew this early on. And that, as the court put in paragraph 30 of the court's opinion from July 31st, there was a progressive trail established of how these rounds could have gotten to the rest set through Mr. Kinney. Now, Ms. Morrissey wants to denigrate that idea. But finally today she said, well, I guess in a wild speculation, you could say Mr. Kinney brought them. No, that's a real possibility. That's something the jury should have been able to consider, but they never wanted to acknowledge any possible defense theory, which is why they suppressed everything. Because Ms. Morrissey didn't think it was relevant. With regard to the Hague report, Ms. Morrissey made extensive argument about how we should have divined these microscopic or very small damage to the trigger and sear through looking through thousands of pictures and having our experts somehow divine the opinion of Mr. Hague that this or come to the same opinion as Mr. Hague. But what she's ignoring and trying to get this court to ignore is the failure to produce that report from the main
Ooh, Heather, we'll watch it afterwards. Is it live or is it pre-recorded?
state witness who was opining on whether the gun functioned correctly. And I just accepted that at trial because I accepted his answer that there was no modification that affected, and no modification other than the FBI testing, which that was the case in the pretrial interviews. That was a case at trial. Ms. Morrissey said pretrial interviews are where we can figure these things out. Well, we couldn't even figure out at trial because he didn't answer the question in a truthful manner. What he said was there is no other modification to that trigger or sear. Now that's false. And Ms. Morrissey wants to conveniently skip over that and the idea that we should have had this and it's no harm, no foul, even though we have abundant proof of Ball's testimony and she's admitted we didn't get the report. That's something we could have absolutely crossed on and used under 14-251 on this idea that the court pointed out in Mr. Baldwin's order on the—
Oh, I don't remember who posted it. Was it Law and Crime or Court TV? I think one of Sarah Boone's previous attorneys was on there. Was that Law and Crime?
negligence of third parties and the proximate cause argument. Your Honor, regarding the Seth Kinney statements, I did read it all. I boiled it down in the reply to the 8 most important, and that's why I wanted to get to the court to consider. Ms. Morrissey tries to, again, run away from the idea that she suppressed something by characterizing as we had it all. Well, we didn't have it all, and we didn't have it specifically all from Seth Kinney's mouth. So that's not true, the arguments that were just made, and we could have crossed him on that, and he was an important state witness, as this court knows. Your Honor, with regard to the Teskey rounds, what Ms. Morrissey didn't address at all is not the new trial grounds, but we've asked for a dismissal under the court's inherent power. And the whole Teskey argument, and I've been open about it, I didn't see those till 2 days before the end of the trial. At that time, there was no way to do anything with them because they had been suppressed in essence by the state not getting them, and Mr. Teskey not wanting to touch them. For the exact reason that Ms. Morrissey accused him today of planning rounds. That's the reason why he didn't do anything with them. But you're
I didn't even notice anything until you guys said that. Black licorice is disgusting. Do you guys know where that was? I could have sworn one of Sarah Boone's previous attorneys did an interview with, was it Court TV? I don't, where's the video?
Your Honor, the Teskey evidence and the court's opinion in Baldwin goes to the remedy of dismissal because the egregious nature of this prosecutorial misconduct in this case, specifically by Ms. Morrissey, her false testimony does a blow to the whole system of justice. It's not just to this case. As this court appropriately found and was warranted in Mr. Baldwin's trial, this affects the whole system. Why people respect the system, they voluntarily turn themselves into jail when a judge rules, is because they have respect and confidence in public trust. What Ms. Morrissey did in this case is she destroyed public trust across the board in the Rust prosecutions on a case that was watched by the nation and the world. A case being paid by the taxpayers, one of the biggest debacles, ethical misconduct, probably in the history of New Mexico.
Ooh.
But this court appropriately dismissed that case to restore and maintain and uphold the integrity of our system. And so I'm asking the court to consider doing that in this case as well, because it's not fair and it's not right when the prosecutor doesn't play by the rules and it doesn't engage in fair play. That undermines our entire system.
All right, thank you for your presentations today on this particular motion. I will consider these arguments.
Oh no, she doesn't decide today?
As well as the pleadings. I will issue an order.
Not today?
I plan to issue the order early next week.
Oh, next week.
All right, but at least next week. All right, let's move on to the motion for immediate release.
Yes, Your Honor, and that really, I think, is predicated upon the court's ruling, whichever way the court would rule on the instant motion we just argued. So I'm open to suggestions of this court or counsel. Judge, I don't know if it's ripe until this court rules.
Next week, she says, next week.
I think it's ripe. You've got section 3111(1)C, and you've also got the case law.
Yes, Your Honor, and with that, I am asking for immediate release, and some of the same arguments we've already presented with regard to the Hague third report. Judge, this is on appeal. it's been remanded on a limited basis for this court to rule on a motion for new trial. I know that the state has responded that there are issues that Ms. Gutierrez-Reed has had with regard to statements she's made. But Your Honor, the fact of the matter is, while she was on pretrial release in this case, she didn't have any violations. She didn't go anywhere. She's not intending to flee. She's not intending to try to avoid prosecution. Your Honor, and I would submit that if, or to avoid her obligations to this court, I would submit that she's not a danger. If this court were to enact conditions, she doesn't have firearms. She could be on house arrest or whatever conditions this court deems appropriate. While this case is pending, whatever decision this court makes early next week, but she'd be allowed to be released pending the appeal. One of the problems, Your Honor, is that the length of time of this appeal, if this case proceeds to appeal, is likely to take longer than her sentence. And that's just a fact of how the system proceeds. And so we're asking, with the issues we've raised, for this court to consider releasing her while this court considers this motion and the appeals court considers it.
I don't know, man. Something tells me the judge is not going to release her.
Arguments.
Ms. Morrissey.
What do you guys think?
Your Honor, the state objects to the release of Ms. Gutierrez. Mr. Bowles indicated that she didn't have any violations of her conditions of release. I think we didn't have any evidence of those violations that we could bring to the court, but we did discover when listening to Ms. Gutierrez's jail calls.
Oh, I think like they're trying to say she lied about her employment, right?
That she was in
and then drinking too.
Possession of alcohol during the trial. Discussed violating the court's order that she not possess firearms during her jail calls. And
yeah, she was like flaunting in those jail calls. We haven't heard the jail calls because they haven't been released yet, but we saw some of the transcripts.
She has already signed a guilty plea to a felony in her other case. So Mr. Bowles' argument that she doesn't have any other
bringing a gun into a bar
criminal history. I know that he argued that initially in his motion, and she has now since signed a guilty plea in that case. So I'm not trying to beat him up over that when he made that assertion in his initial motion.
Oh no, I live in Florida. We didn't get flooded, but my aunt in Georgia said her home was destroyed. Oh my God. Yeah, my one of my mods live in Georgia, and they said they had there was like some homes near them that were like completely flooded.
Was accurate in terms of her convictions. It is no longer accurate. And based
these
on
frames are Masunagas. They're I think they're Masunagas. Yeah, they're Japanese frames.
Those issues, we would ask the court to deny Mr. Bowles' request to release Ms. Gutierrez. And I will say that one of the things that has mystified me in terms of the way that Mr. Bowles is handling his appeal, he's filed more than one motion before Your Honor asking that the court release Ms. Gutierrez. I think this is the third such motion that I have responded to. I think the court has only heard two of them because one of them was never set for a hearing. But if Mr. Bowles has concerns about the fact that his appeal is going to take so long that essentially Ms. Gutierrez will have served her entire sentence by the time his appeal is over, I don't understand why he isn't addressing that with the Court of Appeals. I think that he can do that. I think that he should do that, and he should have already done it. So we would ask this court, based on everything that we've gone through this morning with regard to Ms. Gutierrez's motion for a new trial, the 6 factors that have to be met in order for that to be granted. I have never seen a case in the state of New Mexico where the district court dismissed a case post-conviction based on discovery issues, and I don't think that Mr. Bowles has pointed to such a case. So I don't know that asking the court to dismiss the case against Ms. Gutierrez based on the 2 issues that Mr. Bowles was unaware of during the trial is appropriate. The appropriate remedy is motion for new trial.
Let me tell him how to do his job.
He can't meet those 6 factors. So I remain confused as to if Mr. Bowles has concerns about the length of time of the appeal and how it relates to his client's sentence, file a motion asking for release before the Court of Appeals, because they have a better idea of how long their appeal is going to take than we do. But for some reason, he's not done that. So we would oppose Ms. Gutierrez's release. It sounds like the court's going to rule early next week. So certainly if the court rules that Ms. Gutierrez gets a new trial, the court can immediately release her. I'm not sure the court even needs to have a hearing on that. I think that's well within the court's power. But the state objects to it for the record. Thank you.
Your Honor, just briefly. Yes, Your Honor, thank you. Just briefly. Your Honor, the reason why we were asking for dismissal in this case is that it is the most egregious case I have ever seen of prosecutorial misconduct. And there's always an instance where you have to ask a court for something you're compelled to do on behalf of your client, because there's no case I've ever seen that is this bad. Mr. Baldwin's lawyers wrote that in their response that they recently filed, and this court appropriately dismissed that case. That's why we have asked for the dismissal remedy, because this case is so egregious. What happened? Lying, cheating, hiding evidence. Second, Your Honor, with regard to the release, we wanted to go through the chain of command. We wanted to address that with this court first. And then we will, depending on this court's ruling, we would go to the Court of Appeals next. But I wanted to respect the chain of command and respect this court's authority over the proceedings. And this court had previously ruled on those issues. So that's why we filed it.
Okay.
So, Your Honor, we would respectfully agree with Ms. Morrissey. If this court rules in our favor early next week, this court wouldn't have to have a hearing and could just release her.
All right, thank you, counsel. Again, I appreciate your presentations today, and I do appreciate your briefing. I'm going to consider your motions. I will address them in two separate orders. Your motion for release, immediate release under 5402, and then the order on discovery violations and inherent power, new trial and dismissal. All right, thank you.
Oh yeah, I started speeding up towards the end when the judge was talking. I was getting really hungry.
We are in recess.
But I want to watch this. Hold on. Let me see. Someone says Mr. Owens is... It's Vinny! Let's see. Mr. Owens. I just want to listen to Mr. Owens. Is he around here? Do you know the timestamp when Mr. Owens is talking? Mr. Owens. Mr. Owens. Wait. No, I'm just kidding. Oh, I think right here, right? Wait, and Frank Bankowitz? Wait, Frank is there? What is Frank doing over here? After 46 minutes? This is 43 minutes long, though.
So I know there may be some things you can't talk. Sarah Boone's new attorney, James Owens, is with us. And
is it the new attorney next to the old attorney? Is that the Frank Bankowitz? I've only seen the back of Frank Bankowitz. I have no idea what he looks like. For some reason, I always just thought maybe Frank Bankowitz looked like Bernie Sanders or something. I've only seen the back of his head.
James, I understand you're preparing for trial, so I know there may be some things you can't talk about. I just want to let the viewers know that that's part of the deal when we bring on the lawyer. And thank you so much for being here. Also with us, Sarah's former defense attorney, Frank Bankowitz. So thank you both for being here. I do appreciate it. So I wanted to point out a couple of scenarios here and kind of get your take on it.
Is Sarah Boone's story consistent? That's the question.
And I'll begin with Sarah Boone talking about when she woke up. In one statement, Sarah woke up to her cell phone ringing multiple times around 1100 hours. This is in a police statement. She went downstairs, did not see George anywhere in the apartment. She then realizes that he was possibly still inside the suitcase. Sarah unzipped the suitcase and found George unresponsive and not breathing. However, on the body cam video, I want to play that so we can see if it's consistent with that version.
When did you do CPR? This morning, when I found it. Before you called? Yes! 1 o'clock right now. I tried, I was awake, but I actually got out of the bed at like 12:30-ish, whatever.
Okay, so James, is there a problem here in when she's getting up, or is this story consistent, at least this part, of when she gets up the following morning?
Thanks for having me, Vinny. I don't think she had a watch on every time they're asking her questions about the times. I'm guessing, trying to give them an answer.
Okay.
So I don't think she should be looked down upon or considered that she's being evasive. I just think she didn't know the time frame.
Frank, from your perspective, is there a problem with her story, or is it something that is consistent enough for a jury to say, hey, every time she's telling the story, she's telling the same story about what happened that morning?
Well, I don't know that you can point to inconsistencies. I think it's, she's nervous, she's upset, she's basically kind of in a panic mode from what I see in the video and what I've seen in the past. And I don't know that you can point to those as being inconsistencies.
I want to show go to another issue here, which is the state of mind that night and what was happening.
Poor Frank. Frank is the one that Sarah called a buffoon, amongst other things.
First, Sarah mentioned that she and George had been consuming alcohol during the night, and she went upstairs and passed out in her bed. But here she is in her interview talking about the same issue of drinking that night.
You told me on but you told me on recording, like, that you were not drunk, he was not drunk, you guys were having a good time.
I can't get drunk. Number one, I do not want to get drunk.
We're going to watch this interrogation, I think this weekend.
I don't like being non-compos mentis, having my wits about myself. I don't like feeling out of control.
Mm-hmm.
So
I'm just saying, you're making it sound like he's a raging alcoholic today, and yesterday I was kind of asking you those questions, and you're like a little defensive, like, no, we're not alcoholics.
I'm not.
We are not, you know. But you guys were both sober on Sunday, to your knowledge, because when I said you went and passed out, you were like, no, I didn't pass out, I just fell asleep. So now it's kind of like, what is it? Were you guys drinking and it got out of hand and it got physical?
No.
Or is it?
Sunday was one of the better days that we have had in quite some time.
So where were you guys at on drunkenness, not drunkenness on Sunday? You told us you
Also, this investigator looks like Alec Baldwin from the side angle.
weren't drunk.
No, I was not drunk.
Right.
I was not drunk.
Okay, James, from the beginning of my coverage of the story, that's always been a big issue because you listen to the voice, it sounds like she's under the influence. Is this a problem, the fact that she seems to be denying that they were drinking, denying that she was drunk, or was she actually sober that night?
No, I think they were drinking, and I think that earlier in the day, she to the Publix, which is a short distance away from their apartment.
Oh, she went to Publix? Wait, is this those surveillance footage that are talking about?
And then later on the day,
In today's hearing?
he went a second time to Publix and got another bottle. So both of those and found in the garbage can, and the receipts were found somewhere in the apartment. So they were the only in the apartment that night. So they both consumed. So they did drink quite a bit.
Frank Mankiewicz, let me ask you about that issue of the drinking. Is that a huge problem for Sarah Boone?
Wait, so the attorney is saying that they had 2 bottles of wine. But remember, Sarah said that they first started off with the bottle of wine that they had from the previous day. That was like a half bottle. And then they only drank 1 bottle of wine. But now it's like 2.5 bottles of wine, I guess, because they got 2 from Publix?
That they were drinking, or how does this play in front of a jury, and what does it mean?
I wonder what was her go-to brand of wine.
Well, I would agree with Mr. Owens. They were drinking a lot. They consumed 2 full bottles of wine. They finished one and went out and bought a second and finished it. Whether in her mind at that point in time she can establish whether she was drunk or not, I think that's going to be a question for the jury. And they're going to have to look at all these tapes and look at the actual facts as to what she did, where she had gone, and the fact that she, quote, fell asleep, to me is consistent with being passed out. But that's to me. Fortunately, I don't have to deal with that. Mr. Owens does.
Mr. Owens, number 9 will be representing Sarah Boone at the trial. This is a
play it back.
Mr. Owens,
that's to me. To me is consistent with being passed out. But that's to me. Fortunately, I don't have to deal with that. Mr. Owens does.
He says, unfortunately, I don't have to deal with that.
Mr. Owens, number 9 will be representing Sarah Boone
I
at
meant
the
to say, I don't have to deal with Sarah Boone anymore. Mr. Owens does.
trial. This is a big one now. I think this is probably the biggest one if there is an inconsistency.
Okay.
From the beginning, it seems that Sarah was talking about playing a game of hide and seek, that George willingly got into the suitcase, Sarah zipped the suitcase up, and they were both laughing as she zipped him into the suitcase. But now I want to play the last time, James, you were in court talking about what Sarah's defense is going to be in this case.
Judge, the state doesn't know what happened the 2 minutes prior, or the minutes leading up to, the time leading up to the 2-minute video. The state doesn't know what happened after the 2-minute video. Only Sarah Boone can testify to that. That's for her to testify to.
The appellant has not cited, nor is our research located, any Florida case holding that evidence of battered spouse syndrome is admissible where the defendant claims accident.
This is the best highlight ever between the judge and Mr. Owens.
Rather than self-defense.
Who claims accident?
Are you claiming self-defense?
Yes.
Well, that's the first time that I've heard that.
Judge, I just mentioned it a while ago.
The word self-defense never came out of your mouth.
Judge,
words that you believe that the state's position is, what you believe that they're going to try to establish, that we don't know what happened before and after that video. The word self-defense have never been uttered this afternoon.
Judge, for the record, we're claiming self-defense. We're utilizing the battered spouse syndrome in conjunction with that defense.
Okay. All right.
Okay.
Not accident, as they want to allege.
Okay.
Okay, James, let me ask you, if they're laughing, if she says they're laughing when she zipped them in, how does that equal self-defense? Is that inconsistent?
Wow, they're going to have them answer this right now, right here? Okay. Give him more practice. Let's go.
Well, like I said in court, the video is only 2 minutes long that Sarah recorded of George in the suitcase. So no one but Sarah knows what happened prior to recorded, and no one but Sarah knows what happened turned off the video. So her to testify to and explain what happened.
Oh, so okay. So I'm assuming, because I think he did want her to testify and talk about this, but oh boy, I think he was the one that said that he was he considered himself as an attorney that was rare because he prefers to have people to testify. I think I could have sworn he was the one that said that he wanted to have his like criminal defendants to testify. Was that him? I think it was him.
All right, James Owens and Frank Bankowitz.
Okay, he needs to come up with a better answer than that. That's not going to convince the jury. You know, you don't know what happened before and after the video. Okay, yeah, exactly. We don't. We don't know if it went her way or if it didn't go what she said happened.
Staying with us, still to come. What?
That's what I'm supposed to do. I'm afraid of it. I'm afraid of his family.
Oh, this is from 2019, okay?
One of the most successful.
All right.
Sometimes that's what I'm supposed to do. I'm afraid of it. I'm afraid of his family. My son can't come over here because he's here.
That's body camera video from a different incident involving Sarah Boone and George Torres.
Okay, so is there more interview? Oh, we're going to ask more questions?
It brings me to my next question, which I think will be a major issue in this case. Was there a history of domestic violence? And her former attorney, Frank, from September 4th of 2019.
George was hiding in the bathtub upstairs. Okay?
Yes.
So, he gave me his side of things. I need you to give me your side of things in person right here. And we kind of talked on the phone, but I need you to tell me why.
I haven't seen this yet, but we had someone in my chat that kept telling me to watch this. I haven't seen it yet, so this is my first time watching it.
Happened tonight. So what happened?
Pardon my language, because it's not me. I was called and,
okay.
And I'm not a mother to my son.
Okay.
All the while, nonetheless, I was sleeping before that.
Okay. So you're woken up to him calling you names. Is that what you're saying?
I thought that I'm like, feed the beast, go outside and smoke a cigarette with him.
Okay.
Try to calm him. Well, the whole time I was there saying nothing. Nothing. I was called names.
Okay. So you guys were smoking a cigarette and he was calling you names, being verbally aggressive with you. Verbally abusive.
Before that, where I'm like, I don't want to get hit anymore, so I'm just going to go downstairs and smoke a cigarette with him to try to calm him down.
Okay. So you're saying, okay, I'm trying to get a timeline of things. So start from the beginning and give me the timeline.
Was it I was asleep?
I don't, not literal time, but in a reference of incidents, how they occurred tonight.
How's she going to claim the suitcase was used for self-defense, though? Okay. Maybe she's trying to convince us that he was running, coming after her. However, he was really, really drunk, okay? She somehow laid out a trap, opened the clamshell of the suitcase, and then he was chasing her around. She somehow got him to trip into the suitcase, and in that short moment when he fell in there, she was able to zip him up really quickly. Maybe? I don't know. I have no idea how she's going to claim self-defense. I have no fucking idea. That's one scenario. And then, you know, she didn't want to let him out because she was afraid for her life. I don't know if she's going to come up with that story and tell the jury that because they're not going to believe that. But, you know, we've heard a lot of weird, like Courtney Clenny, the OnlyFans one, when she said that Christian Obenzelli was coming at her, she like miraculously just like threw a knife and just landed perfectly deep into his chest, something like that. Who knows? Who knows? Who knows?
I was asleep, and again, he comes in and wakes me up.
He wakes you up. Okay.
He's out of sorts.
Okay.
So I'm trying to figure things out.
Okay.
Where it's like, don't make it worse. Just go downstairs with him. Because he gets mad at me because I go to sleep.
Okay.
I go downstairs, smoke a cigarette. The whole time I'm being belittled.
Okay.
Pardon me for saying talk about.
Okay. Frank Bankowitz, is there a history of domestic violence in this relationship? And if so, how serious?
Absolutely. There's a long history of domestic violence, and I'm sure all of that's going to come out or has already come out with regard to the battered spouse defense. That's one of the principal elements, is to establish a history of abuse. And there was a long history of abuse in this case, history of hospitalizations, history of broken bones, history of arrests. It's a classic situation of battered spouse syndrome, in my opinion.
I want to put this up on the screen. Sarah State.
But I guess I have to look this up. Is battered spouse defense, is that mostly going to be one-sided though? What happens if it's like two people in a relationship equally beating each other up? How would that be categorized? Or would that be different? I guess I should look this up. What's the latest Clenny case? I saw that the parents were arrested. The parents were arrested because of the stealing the digital information, or the laptop thing. I think like hacking into the laptop thing. But then they ended up getting that case dismissed, I think. However, I think the judge ruled that the state can keep the communications between the Clennys and the attorneys or something. Oh, fuck, I don't remember. I read an article recently. But, I mean, honestly, in terms of when the fuck is she going to have her trial? No fucking idea. I have no idea. I don't know what's going on with that one. I don't know.
This is June 15th, 2019. She was beaten up, face, head, legs, and arms. She stated that she begged George to stop, and George stated, "You're going to die." Sarah stated that George punched her in the head, flung her off the bed. Sarah stated this incident occurred due to George being upset about Sarah speaking to a male. James Owens, this history.
Sarah stated that she was dating George for 2.5 years. I observed a lump that was red in color in the left side of Sarah's face under her hairline. She also had scratches on the right side of her neck. Sarah stated the lump was caused by George punching her. She was not sure if the scratches were from today. Sarah provided a sworn written statement. I think this is when George was arrested. Sarah provided a sworn written statement. She desires prosecution and will testify in court. Sarah completed a DV worksheet and was provided a victim's right pamphlet. I then spoke to George. I observed scratches on the right side of George's neck. I asked George how he received the scratches. George stated that he did not know. I then secured George into the handcuffs without incident and placed George in the back of my vehicle. I then read George's Miranda rights from my issued Miranda warnings card. George agreed to speak with me. George stated that he did not strike Sarah and that Sarah did not strike him. I took photos of both Sarah's and George's injuries, uploaded them to the DataWorks. Both Sarah and George refused medical attention. Due to Sarah and George being involved in a dating relationship of 2.5 years, and George striking Sarah causing visible injuries, I placed George under arrest.
That we are uncovering here is the jury going to see and hear about this history.
Yes. They filed a notice of intent to rely on, and
oh man, he needs to fix his microphone.
In the notice and in the amended notice, we alleged that there were prior incidences of abuse, and Dr. Julie Harper to testify on that issue. So yes, there is corroboration in terms of a prior history of George and emotionally and sexually abusing Sarah Boone.
And I'm looking here at George's arrest history. It looks like June 15th, arrested for battery. June 18th, arrested for violation of pretrial release, making contact with Sarah when he wasn't supposed to. August 28th, 2019, a battery arrest. September 4th, arrested for battery. Is all of this connected to Sarah, or are there other cases that are out there? And do you expect the jury to hear the history of George Torres, James?
Yes, I believe those instances relate to the domestic George and Sarah, and I believe there is other incidences. As far as how much comes in, there are rules that come into play in the evidence.
Okay.
I have to make some decisions about that.
James, I hate to cut you off, but we are out of time. James Owens, we appreciate it. Frank Bankowitz, thank you both so much. One of the biggest mysteries surrounding this case has been, when will this trial happen? Sarah Boone on lawyer number 9, but believe it or not, it looks like this time it will happen. We'll see the trial right here on Court TV. The question is, what will the jury say?
Bye, Vinny. Did you see the video for X that day? Not great from. No, I haven't seen it yet. Okay, I know there's a lot of videos that I gotta watch. I'm thinking maybe stream tomorrow or Sunday. Tomorrow or Sunday. Or actually, or next week maybe. Do we have anything next week? Next week we have a. What do we have for next week? Because I also want to cover the Diddy stuff too. We got a lot of stuff to cover. So next week we'll wait for the judge's decision in the Hannah Reid, whether or not she's going to be released, whether or not they're going to give her a new trial. We'll see about that. Oh my God, my dates are all like Boone. Pretrial for Kari Richins. Why do I have that here? Okay, so I think October 2nd, right? October 2nd. Sarah Boone pretrial motion. That's at 3 p.m. Florida time. What else was next week? I could have sworn we had something else next week. Next week. The October. Judge ruling on Hannah Reid release / new trial. Is there anything else? Owens is going to use every trick in the book, as he should. Try to get his client out. The suppression. The suppression thing. That's going to be filed today. I'm going to keep refreshing it. Owens has to file the notice of the motion for suppression by tonight. So he's got another 5.5 hours. Oh, really? You may have jury duty? Good luck. My roommate was summoned for jury duty, and he tried to get out of it by saying, I have a roommate that streams true crime stuff. And they're like, okay, so. They ended up dismissing him anyways for like other stuff, but yeah, good luck at your jury duty. Legend has it Owens is still saying, Judge, can you hear me? Judge? You funny, Kay, you funny. All right. Okay, so maybe I'm not too sure. Maybe this weekend, maybe next week, we'll do the interrogation and all that stuff. I'm sorry, I've been pushing this for like a while now. I don't know. Join the Discord. We'll have the notifications on there. Okay, you guys haven't already. Join the Discord. Hit the like button. Check out Vinnie Politan. And gosh, what did we do today? I feel like we did so much today. Just a recap on today's stream. Let me get Vinnie off the screen. Bye, Vinnie. Just a recap on today's stream. We had a very very messy, very audibly distorting hearing today with Sarah Boone. The hearing's a little bit but when I edit it, I can boost audio a little bit. I'm sure Court TV will post on their YouTube channel. So we listened to the pretrial hearing with Sarah Boone. Owens has to file his motions to suppress tonight. Next week, they have to depose the Dr. Brandon. Next week, they're also going to have another pretrial hearing, which we'll be here for on Thursday. Let's see. Judge will make a decision about makeup and hair, I guess next week when they make their argument. What else did we do today? We covered the Baldwin, well, not the Baldwin stuff, because the Baldwin's already over, but we covered the hearing from yesterday with Kari Morrissey. She's back. Mr. Bowles is Hannah Reid's attorney, trying to get Hannah Reid a new trial or get her released for the time being, get her released for the time being. And then we listened to the Vinnie Politan Investigates, where Mr. James Owens and Frank Bankowitz, attorney number 6, were on the panel. I mean, honestly, I think, this is the exposure that Mr. Owens probably wants. I think it's good exposure, Come on Court TV, get to talk to Vinny, All right. And then only have to deal with Sarah Boone for like another month. And then that's it. If she gets convicted, have someone else deal with the appeal. All right, y'all. I hope you guys have a good one. You guys take care. Have a good weekend. Today was a long stream for a Friday. Hope you guys have a happy weekend. Happy Friday. And feel free to join the Discord. If there's anything else about this case that you want me to cover, post it in the Discord. If there's anything that I missed, post it in the Discord. Also, if there's any other cases you want me to cover, post that in the Discord as well. I've been following the Koberger stuff, but there really hasn't been anything that I've been wanting to really report on that. Koberger, they are doing it. The new trial is going to be held in Ada County, not in Latah County. I think Ada County. Is Ada County where Lori Vallow and the other dude, Chad Daybell? I think that's where they had their trial, right? Was it in Ada County? I do want to cover the Diddy stuff at some point. I read the indictment already. What else was there? I wanted to watch the police interrogation of Maddie Soto's mom, in quotation marks, because Jen Soto is a piece of shit. I think that's it. I just have a lot of stuff that I just want to cover. all that before the October 7th trial, which I don't know if we're gonna get to. We'll see. We'll see. Good night, everyone. Take care. Well, I heard that the mom, Jen Soto, I heard she got, I think they offered her derivative immunity. And I think, wasn't that also offered to Wendy Adelson as well? Derivative immunity. I think that's when whatever you testify, they can't use against you, but they can still come after you later on in the future for other things, right? I think I heard that Jen Soto was offered derivative immunity. Let me see. Wendy Adelson, derivative immunity. Did I get that right? Wendy Adelson. Yeah, Wendy Adelson was given derivative immunity. Was Jen Soto? Jen Soto. Oh, I think it's called derivative use immunity. Jen Soto. Derivative immunity. Okay, per this Reddit. Derivative use immunity means that for the purpose of the specific interview that Jen Soto was compelled to have on 4/18, nothing she said in that interview can be used against her in trial. That info she uses can be used for investigative purposes, meaning she can lead law enforcement in the right direction with the info she gives, but they need to find the proof independently from what she says. I think that's the same for Wendy Adelson as well. I think she was given derivative use immunity, where it's like, if she says things, you can't use what she said to, start your investigation. However, if you end up finding the same, if you end up finding an information, you have to make sure that information you found is from your own investigation and not through what Wendy Adelson said. So I think that's the same thing for Jen Soto as well. Yeah, I think that's what Jen Soto was also. Yeah. So they can still go after her. I think they should. Jen Soto, I think she's a piece of shit and didn't protect her daughter. Nobody was protecting her daughter? Nope. The defense crime scene analyst is crazy as a as a bed bug. You have to prove you found it somehow. I'm assuming if you get questioned on it, like, okay, so like how did you, when you were going through your investigation, how did you find X, Y, and Z? And they have to make sure they can prove it in other ways. Like it wasn't through Wendy Adelson or Jen Soto. But I don't know when that would come up. Maybe like in court or something. Okay. Well, that's it for today. Yeah, if you guys weren't here earlier, we'll have the stream chopped up in mini little videos so you guys can watch directly to what you guys want to watch. And then other than that, I hope you guys have a good weekend. Thanks for joining us on both Twitch and on YouTube. I have a roommate who commits true crime stuff. Yeesh. Thanks for the stream. Bye, Wade. Have a good one. Bye, RP. Kathleen, Pseudo, Karen, Miss Melanie, Shaban, Heather, Mac. Yeah, you guys have a good weekend. We have a Lauren here. See ya. I'm curious if I'm curious if that apartment complex they lived in was government subsidized. You know what? A long time ago I did dig up a bunch of information about the apartment they were living in and how much income they were getting and how much they were paying for rent. I don't remember if it was like if they were living in like a Section 13 situation. I just think that I think her and George like split the rent. I know George didn't have a job at that time, and Sarah said he was really stressed about it. But I believe Sarah was still getting money from her ex-husband, like spousal support or something. That's what I heard. I don't remember if I ever confirmed that. Have a great weekend. Yeah, you guys take care. Bye, lady. Have a good one. I need to go eat lunch. Oh my God, it's so late. I'm so hungry. I'm starving. Bye, y'all. I don't know. One thing just led to another, and then I just wanted to cover it all.